Appellate side mentioning.
Appeal arising out of an order passed in writ petition, wherein I was paying for diverse orders.
Yes, yes. When was the order passed? I mean, you are asking for listing.
My lord, may I be permitted to mention?
When did you get enrolled?
2020.
23.
2020.
2020.
I have appealed with you.
My lord, may I be permitted to mention?
Yes.
I crave leave to file an appeal without certified copy.
When was the order passed?
One was on 5th February and one was on 13th February. Much obliged.
Lordship, kindly recollect that this matter of appeal against the Birbhum Central Cooperative Bank, I am led by my learned senior counsel, Mr. Milan Bhattacharya. This is running item number 52 as a specially fixed matter. Some petitioner's condition is serious.
Please don't ask for upgrade.
Precedent, Lordship.
Mr. Mukherjee, then let us, no hard feelings. Let us release it. Try your luck elsewhere.
Lordship, this matter was already parted by the earlier bench. Lordship, I am not saying.
No, but we cannot. Every matter is important to that particular litigant.
Sir, I am not pressing.
Sorry,
Some
all right.
precedent be given.
Don't press.
Client-
Don't press.
Yes,
One application for extension of interim order, other is the restoration application.
Lordship, may I be permitted to mention a matter for early hearing? Lordship, kindly allow me to indicate, Lordship, in
We
this
cannot, whatever the reason is. Sorry. It's called the list.
Appellate side daily list item number 1.
Is it that passport matter? No. No. All right.
Item number 2.
The item number 2, Lord, I am for the appellant. Lord, there is the two appeal, Lord, two appeal against the same impugned judgment. Lord, Lord, both appeals should, Lord, requires to be heard analogously. Lord,
Your client is so keenly interested in the matter. That's 2013 appeal. No steps taken. We have got it listed.
Lord, kindly fix any date. I will do this matter, Lord. Any day, Lord.
Paper books are ready.
Paper books are ready, Lord. I will. They require the paper books. I will give them a photocopy, Lord.
Give them. We will just say not this week.
Not this.
Huh? Shono.
Kindly gives us a fortnight. I am appealing for the Howrah Jilla Parishad.
Acha, lekho. Number 2. This is an old appeal of 2013. Stop. The appellants showed no interest in proceeding with the matter. Stop. The matter was listed at our instance. Paragraph. Learned advocate for the appellants says that he is ready to do the matter. Stop. Learned advocate for
Howrah Jilla
Howrah Zilla Parishad seeks 2 weeks time to get prepared. Paragraph. Let this matter be listed again on Bulado Dushapta Vade.
along with our matter, we have final.
Huh? Part 6. Under the heading to the hearing to. So say we hearing. Let we mat director diyechen dekho number ta dao.
FMA, final.
FMA. Such and such be listed on that date immediately after this matter.
After 2 weeks, Lord.
তোমার পেপার বই আছে?
But there's an order, Malak, that the paper was prepared in this appeal, Malak, that is listed today, will be used for both the appeals.
Very well. না আমাদের পেপার বই আছে তো তখন সেদিন বলবে নেই আনিয়ে নিও হ্যাঁ
Item number 3. 4. 5.
Lord, the 5, Lord, I pray for not this week. On this, Lord, I have been instructed by the clerk of the advocate on record. He has not come to court today, Lord.
appellant
Appellant.
appellant not this week
My Lord.
on the prayer made on behalf of the appellant comma let this matter stand adjourned and be listed again on Monday date দিয়ে দাও
Item number 6.
Sixth, my lord, I am appearing for the appellant, my lord, led by Mr. Satyanath Mukherjee. Suppose we appear in virtual mode. Very well, my lord, but this matter, my lord, the writ petition has been dismissed. So, my lord, we have filed an application for. Oh, yes.
Yes, all parties are here.
Yes, yes. Yes, my lord. Mukherjee,
May it please the lordship, my lord, this is
My lord,
an
that order was
application which
passed
will
on
take some time.
9/11/2017.
I was suggesting for your lordship's consideration, kindly take up the appeal and the application together, have it disposed of on a date convenient to lordship.
Very well. Is it necessary to file informal paper books?
No.
All papers are there.
All papers are there.
All papers.
Uh,
I am led by the learned advocate. Very well, no problem.
you are for the KMDA. Now that is the problem, Mr. Mukherjee. Now, when the learned advocate
That was an
general will be
earlier
available,
That was
That we have to-
disposed of. The OA was
My
dismissed.
understanding will kindly
We are
ascertain the
giving you
date which is
liberty
convenient
to
for learned advocate.
file
you
a
tell us,
fresh
Mr.
before
Talulda,
the
এই করতে কি আসছে বাবা
My
এটা?
lord, I filed a fresh one. When did you file? My lord, I filed.
Any
on
date
27
convenient to
2023.
the learned advocate general, my lord, may you take.
In the third week of March, if a
3rd week of March, that far off. Give us a date, Mr. Talulda, give us a date. দেখো, the appellant's writ petition was dismissed by the learned single judge by the impugned order, judgment and order, impugned judgment and order. Stop. Paragraph. Mr. Shoktinath Mukherjee, learned senior advocate representing the appellant oblique writ petitioner, says that the appeal and the application may be heard out together. Stop. All papers that were available before the learned single judge are annexed to the stay petition filed in this appeal. Paragraph. We welcome such suggestion. Stop. Paragraph. Paragraph done. Let this matter be listed again on, yes, 19th March. We have no problem, but
Mr. our leader is here.
Mr. Mukherjee, they are suggesting 19th March.
Lord, if it's convenient to them, an earlier date may be fixed, because in the meantime, they're proceeding with the work.
19th March is very far away.
Very
That's
far
not fair, Mr. Taludar. Yes. On. আজ কত তারিখ?
No, it is holiday. It is holiday.
8th holiday, not the 8th holiday.
8th holiday. Why?
Eight March.
8th Friday.
8th March 8. 8th March, Mr. Mukherjee.
Yes, my lord.
March
Date
8.
to lordship.
March 8. March 8 as the last item under the same heading, because it will take some time.
Yes.
As the last
Uh,
item,
And the same heading, and under the heading
application heading, but the last item.
Very well, Miller. We are not opposed. At least it will be called. Oh, certainly, Miller, I am looking into it. But we are filing my affidavit of service.
Affidavit of service filed in court, we kept with the record.
বলেছে তুমি দরকার হলে করে দিবে এর মধ্যেই তো সবই আছে
না, এটা আমাদের জন্য বাইন্ডিং করেছি।
ওটাই ওইটা এভরিথিং হ্যাজ বিন সার্ভড মেমো দেখো ম্যাডাম মাছ আপনাকে
Item number 7.
I am for the respondent. Respondent number 6, my lord.
I am for the appellant.
You are for? No other party?
My lord, state and my lord, the HITCO is a party.
HITCO. You are for HITCO?
State Mr. Learned Advocate.
Who?
Don't-
You are not appearing. So all parties are here.
Yes.
Mr. Dhar, second call. Second call, you will be the first matter to be taken up.
Item number 8.
State of West Bengal. Pass over.
Item number 9.
My lord, I appear on behalf of the petitioner opposite party.
Mr. Mahato, second call. Second call.
Item number 10.
Your Lordships, the appellant are represented by Mr. Shumon Dutt. He is on his legs in another court, Your Lordship.
Pass over.
Item number 11.
My lord, I beg to appear for the petitioner. My lord, the problem is, it is the Samobai Samiti upon which it could not be served. It is showing that it has reached to Daspur post office at 19. After that, it has 2 days. The peon or the postmaster, I don't know, my lord, could not cover the 3-kilometer distance.
Pass over. Pass over.
Item number 12.
মানে praying for a Passover.
13.
In 12 lordship, I appear for Keynes lordship.
Lordship 13 for praying for not today. Current learned advocate Dilip Kumar Sinha has lost his mother today, Lordship.
Mr. Dilip Kumar Singh, you are only not today. On the ground of bereavement in the family of learned advocate on record for the appellants, comma, accommodation is sought for, stop, paragraph as requested, comma, let this matter stand adjourned for the day. এই শোনো, এদিকে শোনো একবার।
Item number 14.
But 14, I'm praying for a Passover.
Passover.
Item number 15.
কি হচ্ছে?
Item number 16.
My lord, item number 15, this learned advocate Sumita
We have passed it over, madam.
not this week, my lord.
Why? Next 16.
Sorry, my
You are
lord.
for the appellants? Respondents?
Respondent 4 and 6, my lord.
First call, Mr. Bandyopadhyay, everybody not present. Pass over.
Item number 17. 18.
17, my lord, I am for the appellant, led by Mr. Haldar.
Cholo.
Item number 18.
Second call.
Item number 19 to 21.
My lord, praying for a Passover.
22 and 23. 24.
Other side is not here. Other side is not here. Pass over.
25 and 26. 27. 28.
28 lordship, I am appearing with the appellant also.
29.
Passover.
30. 31. 32. 33.
Expression application within time, my lord.
Within time.
Within time, my lord.
देखो दाओ application টা দাও। When was it dismissed?
My lord, actually my
Date of,
brief.
don't worry. This is an application for restoration of MAT 1664 of 2019, which was dismissed for default on May 4, 2023. Stop. The application has been filed within the prescribed time period. Paragraph. Having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the appellants on the day the matter was dismissed for default. Stop. Paragraph. Accordingly, the order dated May 4, 2023 is recalled. 2023, is recalled. Stop. Mat such and such is restored to its original file and number. Stop. Let the appeal be listed next week. Paragraph. Can such and such is disposed of.
Appeal is ready for hearing, my lord. Paper book has been filed, my lord. Biplab.
Yeah, next week under the heading hearing. Hearing আছে তো কি আছে?
Hearing আছে। Deep level আছে।
34, 35,
Go. Have you served? Affidavit of service? दियो ना affidavit नहीं. Not today.
$36, 37, 38, 39, 40, 41, 42,
My lord, in item number 42 for the private respondents.
43, 44, 45, 46, 47, 48, 49, 2nd call, item number 1.
This is a very old matter of 2013. Stop. The appellant showed no interest in proceeding with the matter. Stop. The matter has been listed at our instance. Paragraph. In the first call, neither in the first call nor in the second call, anybody appeared for the appellant. Stop. Obviously, the appellant is not interested to proceed with the matter. Paragraph. Mat such and such is dismissed along with can such and such.
Item number 3.
Stands vacant. 3, same order.
4.
Teacher, দেখো অনেকগুলো can আছে, হ্যাঁ, can গুলো mention করো।
Lordship, I am for the petitioner, your lordship, but this is an old matter, your lordship, and I haven't the client is not communicating with us, your lordship.
So why even bother? Why even bother?
Kindly allow me a few days' time, your lordship.
1 week's time, find out if he or she, whatever, if they are interested.
Yes, your lordship.
Take instruction, but before that, take material instruction. Do you know what that is? When were you enrolled, madam?
Your lordship, I have enrolled in 2017, but I didn't continue my practice.
You didn't continue.
Your lordship.
You ask your senior friends what material instruction is. Very important. Yes. This is an old matter of 2014. Stop. Learned advocate for the appellants seeks a week's time to obtain instructions. Paragraph. Let this matter stand adjourned and be listed again on সামনের বুধবার করে দাও. Next Wednesday.
Item number 7.
Yeah.
For the
All parties are here.
proceeding.
All parties are here.
Yes.
Doesn't matter so long as you have served.
My lord. Yes. Section 5. There was a section 5 and a section 5 was allowed
by my lords. The fact of the case is, my lord, initially an acquisition proceeding started under Act 1. Section 4 issued. Notification was issued. Subsequently, I filed 5A under section objection under section 5A of Act 1. Thereafter, state chose not to proceed with that particular acquisition proceedings. So, state did not dispose of my 5A objection. Thereafter, state came up with a new acquisition proceedings again under Act 1
For
requiring body HITCO. Thereafter, again proceedings under Act 1, Section 4. That Section 4, well, their particular compliance has not taken place.
But in the
And
meantime,
the-
possession was taken over.
No, no. Well, under this second time proceedings was read with 17(4), read with Section 4. And the particular, kindly come to the single bench.
What is the project,
observation.
sir? What is the project?
Township, for the purpose of township.
New town.
Possession is still, there is no construction, nothing.
There's no memo of possession, nothing.
No. Throughout the writ petition, I enjoyed the status quo order. Now, kindly come to the finding of the learned single judge. That is at inner page 7, or my lord can.
No, we'll go through the entire judgment.
My lord. কোনো জায়গা থেকে ওটা ঠিক হয়ে
Yes.
Now, my lord, learned
Is your only ground that the third mode of publication was not
not done.
resorted to?
Yes.
That is the only ground.
Violation of subsection 1 of section 4. That is one of the grounds. My lord, I need to see, my lord, whether any notice was served on me under section 9. Then third would be, my lord, whether award was apportioned or not.
What do you mean you need to see? Either you
My
have
lord, nothing has been disclosed by the state.
the affidavit was not called for,
Yes,
not filed.
they filed, but they haven't disclosed about the award. Until unless I see the award, I cannot find whether the award was apportioned or not.
All papers are before us.
My lord, yes,
All papers.
my lord, but without award and without the notice of under section 9. These two things, my lord.
Did you file affidavit before the learned single judge, state?
Yes, yes, my lord, they have.
They appearing for the state lines.
Then what are you doing here? Not appearing.
আপনি এফিডেভিট ফাইল করেছেন নিচের কোর্টে সেটা জজ
We are merely asking, did you file affidavit or not? Will you not take instructions, sir? You are appearing for the state. কি বলবো বলো?
My lord, affidavit in opposition filed by the respondent
Fine.
number 2 and 3
You have
and
annexed.
6. I have annexed in my stay application.
So, Mr. Dhar, if you say all the papers are annexed to the stay application, we'll hear out the appeal.
My lord, kindly, my lord, ask them, kindly direct them to bring those two documents only.
One section 9 notice.
One section 9 notice and the actual award.
Award. Very well.
They have annexed only the payment sheet.
The appellants challenged an acquisition proceeding in respect of their land in Rajarhat, New Town, Kolkata. The state took over possession of their land by issuing a notice under section 4(1) of the Land Acquisition Act, 1894, and invoking the emergency power under section 17(4) of the Act. Stop. Paragraph, the challenge of the appellants has failed. Stop. Their writ petition has been dismissed. Stop. Hence this appeal. Paragraph. Mr. Dhar, learned advocate appearing for the appellants, says that there has been breach of the provisions of section 4(1) of the 1894 Act, in as much as the third mode of publication of the notice was never resorted to by the state. Stop. He further says that there is nothing on record to show that notice under section 9 of the 1894 Act was issued by the state to the appellants. Stop. Further, although the state no amount received, you have not received any amount.
No.
Although the state says that an award has been declared by the land acquisition collector, nothing is on record. Paragraph. We are told that all the papers that were available before the learned single judge are annexed to the stay petition filed in this appeal. So hence, comma, instead of having multiple hearings, comma, we propose to hear out the appeal along with the application. Stop. All the parties consent to such suggestion. Paragraph. List the matter next week. How long will it take? We are asking you to produce the award and the relevant file, the
Relevant
records.
file, my lord, that will serve the purpose.
2 weeks. Very well. আজ কত তারিখ? 21 28 6 তারিখ 7th. 7th. List this matter under the same heading as the last item on March 7, comma 2024. Stop. Paragraph. On the adjourned date, comma, the state shall produce the relevant records of the case and in including the notice of under section 9 of the 1894 Act and the award.
And my lord, since my lord, throughout the writ petition, I have been enjoying the
Paragraph. Since the appellants were enjoying an interim order of status quo in respect of the concerned land throughout the pendency of the writ petition, comma, let there be an order of status quo in respect of the land till disposal of this appeal.
I'm deeply abashed. এটা তোমার বই।
Item number 8.
I appear for the petitioner respondent.
That matter where, my lord, the issue was of condonation of delay.
Yes, yes.
Yes, my lord. My lord,
Mr. Gali wanted to cite certain
my lord, may I
decisions.
just indicate, my lord, I had a talk with the concerned officer. My lord, my lord, we have got all the documents to support. My lord, there was an endeavor from 2017 itself. If my lord allows, gives us a 1 week's accommodation, we can put all those documents on the issue of, on the ground of limitation. From 2000, my lord, order was passed on 8th August 2017. In the month, I have all the note sheet with me. In month of November itself, there was a direction, there was a process was started for filing a review. My lord, ultimately, my lord, my entire thing got, but I cannot say much. My lord, the concerned
Don't say much,
no,
Mr.
the concerned
Chakravarti.
person who was handling the case, he was terminated because the files were missing for 2 years deliberately. My lord, he was terminated. But I have all those documents. When there is no want of bona fide on the part of the state.
Why don't you go for a review saying that you have discovered documents showing that their land was not acquired?
My lord,
You may not succeed on the 7 years delay.
my lord,
Liberal as we are, but even then.
my lord, no, my lord, the delays I have seen, my lord, 1500 days. It's not 7 years. Now it has
Very well, come down to 4 years.
4 years.
5 years, let us say.
4
Anyway.
years, but out of which 2 years, my lord, can of the COVID situation. My lord, we can. But kindly allow me to take a chance. Kindly, my lord, a week's times, I'll bring all the documents. If I'm able to satisfy to that extent, my lord, from
Let them try, Mr. Vishwas.
Subject to correction, my lord.
Subject to
Contempt
correction.
petition pending.
Huh?
Contempt petition pending.
But
We are not,
he was
No,
on.
I am telling
Mr. Vishwas, we'll clarify, this will not stand in the way because we have not passed any stay order.
Kindly see the list of dates. If your lordship convince them, then my lord, kindly allow. In this section.
We are as of now not persuaded. We are telling you.
I got your lordship.
But the state says, give us one more chance. We want to bring certain documents to try and impress upon us that there was no leeches on their part. Now we are sure we will not be persuaded again. But give this opportunity, file a supplementary when we will 1 week.
1 week. No, Thursday week was subject to Thursday week.
Thursday week. Learned advocate, Mr. Chakravarti, learned advocate for the state, says that leave may be granted to file a supplementary affidavit bringing on record very relevant documents showing that there was no intentional delay or laches on the part of the state in challenging the order of the learned single judge. Stop. Such documents would be very relevant to the application for condonation of delay, according to him. Paragraph. As of now, we are not satisfied with the explanation furnished so far by the state for the inordinate delay of 1500 and odd days. Stop. However, taking a liberal approach, we grant leave to the state to file a supplementary affidavit as prayed for, with by next Thursday, date, with advance copy to learned advocate for the respondent oblique writ petitioner. Do you want to deal with it, Mr. Vishas?
I believe it is not required at least. Let them give.
Let the liberty be there. Let the liberty
If
be
you
there.
will be
Stop.
satisfied, then
The respond with an advance copy to who will be at liberty to file his response within a week thereafter. Within a week
subject to correction. Let them file it. And if your lordship is not.
No. That way it can't happen. Don't take chances like that. We'll keep it 2 weeks hence. In the meantime, we'll be granting you time. If you think it is not necessary, don't file.
We shall. Let it be.
Within a week thereafter. Paragraph lists the matter once again. তারপরে Thursday কি ডেটটা হচ্ছে দিয়ে দাও। Thursday week তো ও ফাইল করবে সাপ্লিমেন্টারি তারপরেরটা।
It comes 7th March.
I'm grateful, my lord.
And our pendency of this appeal shall not.
Paragraph, learned advocate for the respondent oblique writ petitioner says that a contempt application.
Not in respect of this order.
Maybe
Subsequent order.
subsequent
Which is
order,
not as
because
my lord.
they have
My
not.
lord, I don't know why my
Let-
lord.
let-
My
Is
lord,
pending before the learned single judge.
not in
Stop.
respect of this order, my lord would kindly.
Since we have not passed any order of stay, we see no impediment in since we have not passed any order of stay, the respondent oblique writ petitioner may take appropriate steps in that matter.
Much obliged. Get.
Grateful.
Mr. Vishwash, after all, the state has to be given some sort of indulgence because it is an impersonal body. State is
Let
My lord,
them
that is what, my lord,
Let them
latest
exhaust,
judgment
but it is a
delivered by
case for
justice.
not to
My lord, delivered by Justice Dotto, my lord, but this point, so
there is a limit to it.
there is a limit to it. I accept that. But my lord, put us on term, my lord, I would not have been so vociferous. Because here, my lord, no, nothing has been done in respect of this land.
Let
Well,
us see.
Item number 9.
I beg to appear on behalf of the appellant.
My lord, I appear on behalf of the.
On 30th January, my lord, who has pleased to give me liberty to file the
I appeal for
supplementary
Board of
affidavit for
Trustees.
explaining the delay.
Well, I filed my objection as per your lordship's leave. এটা দেন দিয়েছি কপি কপি দেয়নি না এটা কি এটা কি এই তো রিসিভ করেছি হ্যাঁ এটা করা আছে
Have you filed your response?
Yes, madam. Just I have handed over. I have served the copy within time.
Very unsatisfactory, very unsatisfactory. Just knocking on the door. Several dates given when somebody from the department came and knocked on the door of the advocate, saying that why have you not filed the appeal? Not believable, Mr. Mahato. This is a story that has been made up. And look at P1. First, come to your supplementary affidavit. Page 5. Come to page 5, paragraph 10. Paragraph 10, after paragraph 10, and extract. What does paragraph 10 say? On 1st August 2018, the Rehabilitation Advisory Committee, Huldia, in its meeting decided to make an appeal against the order of the High Court dated 11 July. Correct? Then an extract copy of the proceeding dated 1st August is annexed here too. P1. P1, come to P1. P1 is at page 10. Kindly see P1. Any whisper in P1? That decision was taken to prefer appeal? Then this is the way your officers draft. No, Mr. Mahato. This is not a case where we can help you. That's issue.
I'm acting for the whole municipality.
You have nothing to say. State's appeal.
The merit, my lord, only 2 decimal of land was acquired.
Mr. Mahato, merit. We will not look into the merit.
My lord, I cannot, my lord has given me opportunity to file the.
Yes.
I have no, my lord, what are the materials on record? I cannot go below. But the difficulty is only 2 decimal land which is classified as Khamar, not the procedure is that the homestead land.
This will not stop you from filing a review. If you can show error apparent on the face of the order, we can say so in the order also. Provided you can explain the delay in filing the review, that is up to you how you will explain.
But the contempt proceeding is pending. But due to this,
Send them to jail.
but in the
We
main.
are saying nothing. We are not admitting the appeal. That is all. এটা কোথায়? এই বাবা, এদিকে এসো তো। আমাকে delay এটা condonation? না, condonation applicationটা বার করে দাও। Can one. This is an application condonation, can one. কি আমি তো ডিসমিস করছি সাফিসিয়েন্ট কজ কি ডিসমিসড হচ্ছে এগুলো খালি ক্যান ওয়ানটা নাও this application has been filed for condonation of delay of 1779 days in presenting a মেমোটা দাও এখানে আচ্ছা ঠিক আছে in presenting না মেমোটা এখানে নেই আছে there was
report there are some result. It is our calculation.
স্ট্যাম্প রিপোর্টে কত বলছে বলো দেখো bad enough 1096 96 condonation of 1779 days bracket লেখো although as per the note of the stamp reporter the delay is of 1096 days bracket closed comma in the memorandum of appeal against judgment and order dated July 11, 2018 passed by a learned judge of this court in WP 18440 bracketed W of 2015, comma, being a writ petition filed by the respondent number 1 herein. Paragraph. On January 30, 2024, when the condonation application was moved, comma, we were of the view that sufficient explanation for the long delay is not there in the petition. Stop. Acceding to the request of learned state advocate, comma, we had granted leave to the state to file a supplementary affidavit to try to give the state another opportunity to explain the delay. Stop. Such supplementary affidavit has been filed today. You filed today? Stop. The respondent oblique writ petitioner has filed his written objection thereto. Paragraph. In the supplementary affidavit, comma, at paragraphs 8, paragraphs 9 to
Paragraph 10, my lord.
yes, 9 to 23, comma, it is stated as follows. Quote করে দাও। Paragraph. It is thereafter stated that the present learned advocate was engaged in the place and stead of the erstwhile advocate. So therefore, comma, there was no intentional laches or delay on the part of the state in challenging the order sought to be impugned. Paragraph. We have extracted the relevant portion of the state's supplementary affidavit. Stop. We are not satisfied that the same adequately explains the inordinate delay. Stop. It is pertinent to note that in paragraph 10, it is stated that on August 1, 2018, the Rehabilitation Advisory Committee, Huldia, in its meeting, decided to prefer an appeal against the order dated July 11, 2018. Stop. In support of such statement, an extract of the minutes of the proceeding dated August 1, 2018 has been annexed as annexure has been annexed to the affidavit as affidavit and marked P1. Stop. That document reads merely as follows. P1 টা page 10 এ আছে, supplementary 3টে লাইন আছে, দিয়ে দিও কোট করে। Paragraph, in other words, the statement of the deponent of the supplementary affidavit finds no support from annexure P1. Paragraph. The statements made in the other paragraphs of the supplementary affidavit, which have been set out here in above, are not credible. Stop. Nothing has been disclosed in support of such statements. Stop. It gives us the impression that a story has been concocted to try and explain the inordinate delay. Stop. The stand that repeatedly the relevant department's officer knocked on the doors of the learned advocate who had been engaged to prepare the appeal papers, without taking any step for engaging some other learned advocate in view of the inability on the part of the former advocate to prepare the appeal papers, is difficult to believe. Stop. Even if we give allowance for the COVID period, there is huge delay. And as we have said, we are not satisfied with the explanation furnished for the delay. Paragraph, accordingly, this application is dismissed. Stop. এবার অন্য ম্যাটার ক্যানটা নাও। In view of dismissal of the application for condonation of delay, this appeal is not entertained. Of the appeal and the connected application are dismissed. Paragraph, this will not prevent the state government from approaching the learned single judge with an application for review and sufficient explanation for the delay, if the government is entitled to do so in law.
Good.
এই কানেক্টেড অ্যাপ্লিকেশন তো কিছু নেই, আছে? তাহলে ওইটাকে ট্রিটেড অ্যাজ এন ডিসলিস্ট করে দিও।
তারপর করতে হবে না।
Item number 10.
In this matter, I appear on your status.
Your Lordship, on the first call also I had asked Mr. Shuman Dutt is leading the appellant. Mr. Dutt is leading the appellant. Shuman Dutt. He's on legs in another court.
My learned friend is taking my lord the time, but I have some submission, my lord, in this matter. That I shall also take instruction, my lord, 2 weeks time will be given. This is a 2003 matter. They are challenging the notice of 2003 that has been set aside by the their prayer has been turned down by the trial judge, my lord.
What notice?
Your Lordship, I do not believe these are the facts of my case.
Notice issued under section 4 of the
Acquisition notice.
they are challenging notice under section 4. That's why, my lord, I pray for 2 weeks time to.
If I may, Your Lordship, these are not the facts of my case.
Are you briefed in the matter?
I am, Your Lordship, but
why don't you proceed? We will not, tell us what the facts are then. Why are you Sir, what is your good name? What is your good name?
Sir, Shorat Dutt. Your Lordship, Shorat Dutt.
Shorat?
Shorat Dutt.
Shorat Dutt.
Your Lordship, we are not...
You are related to Mr. Shuman Dutt?
I am his son, Your Lordship.
I thought so. Are you prepared?
I am, Your Lordship, but the instructions were to take...
No, that we understand. They want to take instruction. Mr. Dotto, don't take 2 weeks time.
So the entire matter may be resolved, my lord. 2 weeks time, my lord.
Don't take 2 weeks time.
1 week, my lord.
Come back on Monday, because this rest of this week, this bench may not be available. Come back on Monday. Mr. Shorat Dutt, come back on Monday.
Instead of Monday, my lord, Tuesday, my lord, Your Lordship, kindly.
Very well.
Your Lordship, just one. Sorry, not two. No, sir. No. So I believe my learned friend is opposing a different matter. Our matter is, the cause title of matter is Keshosham Constructions.
Which matter are you opposing?
My lord, item number, my lord. Chain. Sham construction.
Keshosham Constructions.
আমরা হয়ে গেছি নাকি হচ্ছে হয়ে গেছে না হচ্ছে
Time নিচ্ছি।
matter is over I have something to say if the matter is over I have something to say
Regarding this matter?
no I never seen the matter.
Yet to finish. Please wait. Yes, Mr. Dotto, please tell us, in which matter are you opposing? He is not appealing.
Sorry, my lord,
Bah.
the brief, my lord, today, my lord, I got the brief, my lord. In respect of my lord, 7 I shall make my submission.
So 10 you are not appearing.
No, 10 of my lord appearing, my lord. 10, my lord,
10 what? 10 is not a 2003
my lord,
notice.
extremely sorry, my lord, I am tendering my unconditional apology, my lord, for that.
Passover?
Accepted with
Your lordship.
No, not today.
Not today, your lordship.
Not today. Come back tomorrow.
My lord, on Monday, my lord, your lordship. I shall take instruction.
Mr. Dutt, this bench will not be available on Friday anyway. So Monday.
Very well.
Matter is over. But why my lord is giving cognizance?
Huh?
Star Sun has been launched. Whenever there is a Star Sun is launched, there may be launching party.
Oh, what?
So don't give any cognizance. His appearance.
Okay. When did you get enrolled?
2022, your lordship.
22. Good. All the best.
Extremely sorry. My lord, I should not, my lord, extremely sorry, my lord.
With cost. Apology with cost. Jao.
No, your juniors must have misled you.
Lord.
Yes. কি হলো?
কিরে, খুলবো না খুলবো না খুলবো না আমরা আছি কিন্তু সবাই
অ্যাপ্লিকেশন ডিসমিস দিলে হ্যাঁ
আজকে একটু হোক একটু হোক হ্যাঁ ঠিক আছে আরে ঠিক আছে ও বলছে কি মামলা কি বৃত্তান্ত দুটো কথা ইংরেজি বলে দিলে কি হবে আন্তর্জাতিক মাতৃভাষা দিবস আছে আচ্ছা আজকে 17 কি মামলা হচ্ছে বাংলায় হচ্ছে তো আজকে 17 বাংলায় মামলা হচ্ছে হ্যাঁ
Yes.
Today, what is the language in code number 17? I was inquiring from him. He is a frequent visitor there. Antarjatik Bhasha Divas. So he was inquiring about that. What is the language today? I know.
Item number 11.
The problem is service upon.
You are for the appellant. You are leading him.
No.
My lord, service upon the Samobai Committee.
আমরা বের করছি
It is, I served a week back.
But we are representing Somiti also.
You are.
Also, we are representing Somiti.
Then there is no problem. Shomiti is being represented, sir.
Then,
Okay, बोलते नहीं कोटे बोलते नहीं
my lord,
When were you enrolled? When were you enrolled? 23. Very well. Mr. Basu, on the second day of my appearance, attending court, second day, court number 12, Justice Rumapal, Section 446 leave, Companies Act. For the mere asking, granted leave, I say thank you, my lord.
This is not expected from Mr. Arijit Banerjee. Because my lord is a legacy. We can say first generation.
No. What?
He cannot say.
Yes, so what we say, they are represented, so service is complete.
Abar.
my lord, Miscellaneous supposed to be kindly, I am praying for not kindly keep it.
Tomorrow it is very uncertain, we'll keep it.
Tomorrow I also he has a wife's health checkup.
Then Monday. Accommodation Monday?
Friday, this bench will not be. I have some problem.
Uncertain, please try to understand. We will be available only till about 12 o'clock.
Apart from that, my landlord's wife health
Yes.
checkup is there. That's why. Friday court বসবে না বাবা শুনছিস তো
Sunday.
এ বাবা ওরাই করেছিস এই সব
Accommodation is paid for on behalf of the appellant. Passover করো তাহলে। এটা second call.
second call
Sorry, sir. Accommodation is paid for on behalf of the appellant. Stop. Paragraph. Let this matter stand
হলো নাকি হলো আমাদের হলো
adjourned and be listed again on Monday. Date টা দিয়ে দাও।
চেষ্টা করবো
appellants, এটা?
Item number 12.
Well, I am for the private respondent, my lord.
Relates to illegal construction.
Before my
Writ petition has been dismissed without.
You challenge the demolition order?
passed by Justice Gangopad. না আমি বলছি
You challenge the demolition order?
We have complained of illegal construction.
Oh, you
by the
have
private
complained.
Well, only one thing, well, before my learned senior friend starts that, well, but they have annexed a new document, well, which were two new documents, well, P3 and P4, well, which was not before the court, my lord, trial court. Well, I was not given an opportunity to, my lord, to deal with it, my lord.
I shall try to deal with my case on the writ petition.
And, well, any new document, lordship knows, well, that for order 4127 application has to be placed before your lordship, my lord.
We'll not look into it?
I will not trace it for the time being. But my submission is only this much. I have made a representation to corporation for illegal construction. The learned judge had also called for the files. He had recorded all that. Also, my lord, thereafter finds that there is some mistake, some lack of proper pleadings. But for that, my lord, a complaint. Now, writ court is not a fact-finding body. I am not requiring the writ court to come to a conclusion regarding the allegation. In this type of matter, I am only invoking the writ jurisdiction to say that the corporation has certain duties under the statute. That duties are to be performed. It is for non-performance of a duty enshrined under the Corporation Act. So, here, my lord,
The only thing, Mr. Sen, you're right, but if misstatement is made.
No, there's no misstatement. Learned judge finds that pleadings are not sufficient.
Let us see the order.
Yes.
28th November.
Yes. That is the only ground. And I would say that my learned friends who appeared, they were also saying that yes, they are open to an inquiry, which is what the Corporation Act subscribes. 401.
এটা বলিনি বলছি কর্পোরেশন তো ইনকোয়ারি করেনি yes the inquiry was done এখানে রেসপন্ড করবে এইটা আমার নোটিংটা কোথায় আমি নোট করেছিলাম ব্রিফটা ওই ব্রিফটা কোথায়
Let us see the writ petition.
Yes, sir. Kindly come to the page 66.
Hey, you have impugned the 28th November, the dismissal order, because there are
Yes, this order is under challenge.
There are two 28th November orders.
yes on in the morning one was passed from after the record was brought on that
Morning and then 3 p.m. Yes, must be. This is the final order.
two orders were passed two
Let us see the writ petition.
Yes. Kindly see page 66, which was my representation annexed to the writ petition.
Corporation,
Lord, Lordship can come to page 68 and starts at 66 towards the bottom, my lord. The said Ganga developer in strict violation of building rules has made numerous illegal construction and made several deviations from the sanction plan that was granted in respect of the said property, thereby posing threat to the building and endangering lives of human going to reside in the building. He will take prompt action for making also illegal construction and unlawful deviation from the building sanction plan granted by the group and with prompt action in demolition. So this is my cause of action for the corporation to consider whether section 401 proceedings, because this is a fact finding inquiry which is to be done. And the statute invests its power to the corporation. I have come up because the corporation did not take steps, because I did not required for a litigant to come to the writ court just on the making of a complaint. My cause of action arises because no step has been taken by the corporation. Corporation is well within its powers to conduct the inquiry and say we find no deviation.
It has been done.
But for that, my lord, it cannot be said with the greatest of respect that I have no cause of action to come to the writ court.
Sir, why don't we cut the matter short? You were agreeable before the learned single judge.
Well,
What no?
Well, what has fallen from your lordship, well, I have understood. Well, on that occasion, well, they have taken the plea.
Did you appear before the learned single
Yes, yes,
judge?
well, I appeared. Well, at that point of time, well, they took the plea that the structural stability of the building was not in accordance with the materials was not given, and there was also violation that there was no beam. Well, we took a specific stand. See, there is no such violation. And my lord, I specifically submitted before the single bench that yes, if your lordship wants to call for a structural engineer, you can lordship can do it. After that, what has happened, my lord? Previously, a report was called from the KMC with the original records. But the learned officers came before the court, my lord. They produced the records, my lord. After being satisfied that it has been recorded in the order, lordship will be kindly, my lord, takes that order, my lord, 28th November, which was passed at 3 p.m. It has been specifically recorded. Lordship will kindly seize, my lord. If I read for your lordship, my lord. 20th November, 3 p.m. order. The original documents being the note of AEC dated 5th August 2021, which was not in the file containing papers, has been produced before me by the assistant engineer himself, namely Mr. Lakhun Chandra Bera, which I have seen. He has not stated anything in his report as to the infringement of any building rules or not. So, prima facie, whatever the finding that has been done by the learned, the honorable single bench, my lord, after considering the original records, my lord, forwarded from the KMC.
What was that report? Which...
Well, report, my lord, lordship will kindly say that report was before the court, my lord. Today, it is not before me, my lord. So, if your lordship kindly, my lord, calls
whether that was a report post representation or not.
Yes. My lord, what a lordship will kindly takes, my lord, before your lordship, lordship will kindly takes, my 12th October 2023.
Mr. Naik, why don't you at least dispose of their representation? For that purpose, if you feel it will be necessary, call them also, call both parties, hear them. If you feel that some inspection is necessary, do it. You are the civic authority. Somebody has told you, maybe wrongly, maybe there is enmity between them. We don't know. But somebody has told you, look, there's an illegal construction. It's up to you to find out. If there is no illegal construction, take no steps. If there is, take steps.
No, my lord, only one thing I'll say, my lord. But this is an issue, my lord, which is pending since last 3 to 4 years. Now, what has happened, my lord, is a joint venture agreement. Now, my learned senior client is also one of the partner in respect to this building. My lord, a company, my lord, a partnership firm, my lord, 3 to 4 partners, but they came with us, and my lord, we have a joint venture agreement. Now, my lord, civil disputes, 7th or 8th time litigations. Now, my lord, what has happened for these reasons, my lord? But the building is, my lord, entire building construction is completed, my lord. But I cannot sell my flat. But all this, my lord, it has been, my lord, entirely, my lord, this KMC has inspected at least 11 times.
Right. So all the more reason, once and for all, let KMC.
The lordship is, my lord, penalizing the, my lord, lordship will kindly, my lord, kindly, my lord.
We can't turn blind eyes when a representation is made. KMC must
lordship will dispose it, my lord. But what I am trying to say, my lord, lordship will also kindly record, my lord, this is a litigation, my lord, which is only in respect to, my lord, to put pressure upon the, my lord, developer. On the, my lord, prima facie, my lord, there is no infringement. Lordship will kindly record that.
Prima facie, who will decide that prima facie?
Well, they're on the basis of the records.
Issue.
Well, on the basis of the records, ma'am.
A judgment and order dated November 28, 2023.
18th of April 23.
Huh?
Yes.
What?
Representation dated below 18th of April 23 at
Yes.
page 66.
Yes. Kilo, comma, whereby the appellant's writ petition being WPA 10686 of 2023, comma, was dismissed by a learned judge of this court, comma, is the subject matter of challenge in this appeal at the instance of the writ petitioner. Paragraph. The writ petitioner had approached the learned single judge with the grievance that Kiran Kumar, his representation to the KMC authorities regarding alleged unauthorized construction raised by the private respondents in the writ petition, comma, was not receiving the attention of the corporation authorities. Stop. Paragraph. The learned judge called for the records and went through the same. Stop. The developers, these are the private respondents, denied having made any unauthorized construction or having infringed any building rules. Stop. They also submitted before the learned judge that any expert may be appointed to ascertain whether there was any infringement of the applicable rules while constructing the building in question. Stop. Paragraph. Learned judge then recorded that the writ petitioner was also agreeable to such course of action. Stop. Paragraph. Thereafter, the learned judge dismissed the writ petition with the following observations. Internal page 2 theke. Paragraph. Being aggrieved, the writ petitioner is before us by way of this appeal. Paragraph. Mr. Sen, comma, learned advocate for the appellant oblique writ petitioner, comma, says that it was not up to the writ petitioner to undertake a fact-finding exercise as to exactly what the infringements, exactly which building rules had been infringed by the private respondents. Stop. It is for the KMC authorities to find that out after due inspection. Stop. When it appears to a citizen that a construction is unauthorized, comma, it is within his rights to bring the same to the notice of the KMC authorities. Stop. That is exactly what has been done in the present case. Stop. The appellant's representation dated April 18, 2023 should be disposed of by the KMC authorities. Paragraph. You appeared before the learned single judge. You did.
One thing, but the original document dated 5th August 2021, is correct. It's not prior to my reference.
Yes.
My lord,
Nothing has been considered which is post-
assistant engineer appeared.
Stop.
Let it be considered by the executive engineer, lordship.
ওইখানে আরেকটা দেবে
Please, my
Mr.
lord.
Sen further says that the original document dated August 5, 2021 that the learned single judge considered and found that the same did not say anything about unauthorized construction, comma, is much is a document
There was a sanction plan.
which came into existence much before the appellant made his representation to the KMC authorities on April 28, 2023. Stop. Paragraph. Mr. Chattopadhyay, for the respondent number 8, the other respondents, they are all together. They are not together.
No. Separate.
Only Ganga.
Yes, I'm for appealing for only Ganga.
Who are the other private respondents?
That's what I
You don't know.
Farmers.
তাহলে শুধু private
They are
respondents.
all the partners. They are all the partners, sir.
Partners of the firm.
গঙ্গা
No.
No. মানে KP.
তাহলে ওটা খালি করো রেসপন্ডেন্ট নাম্বার 8.
Only Gongo.
Paragraph. Mr. Chattopadhyay,
Ganga.
a learned advocate appearing for the private respondent number 8, says that the complaint lodged by the appellant with the KMC authorities is a mala fide and motivated one. Stop. The appellant and the partners of the respondent number 8 firm, you did business together before.
The KMP company, the property belongs to the KMP company. It's a proprietorship firm. 4 partners are there.
Partnership.
Kiran Rai, Bij Rai, all the.
Proprietorship firm cannot have
Sorry, I'm extremely sorry.
The partnership
Partnership
entering
firm.
for development agreement with Ganga developer.
Yes.
Now there are disputes between the.
So you are Ganga.
I only Ganga.
কি বললাম? Motivated and mala fide and motivated. না তারপর কেটে দাও. Stop. Civil disputes are pending between the appellant and the respondent number 8. Bracket লেখো Ganga developer. Civil suits are also pending.
Many
suits are also
2 suits are pending.
2 civil suits are pending between the parties. Stop.
Criminal.
The complaint has been lodged only to harass Ganga and its partners. Stop. Ganga has not deviated from the sanction plan in any manner at all. Stop. Paragraph. We have also heard Mr. Naik, learned advocate appearing for KMC. Stop. He says that KMC will abide by whatever direction the court issues. Paragraph. We are of the view that since a representation has been made by the appellant to the KMC authorities, the same should be disposed of in accordance with law, observing the principles of natural justice. Paragraph. Accordingly, we direct
Number 6.
the respondent number 6 being the executive engineer, bracket building department, bracket close, Boro Roman 1, Kolkata Municipal Corporation, to dispose of the appellant's representation dated April 18, 2023, made through his learned advocate, Sri Sudipto Kumar Bose, bracketed of page 66 of the stay petition, bracket closed, in accordance with law and the applicable rules and regulations, comma, by a reasoned order, comma, within a period of 8 weeks. From 8 weeks is all right.
But a physical inspection may be.
From the date of
If they
communication
only
of the
that,
order.
let them decide. We will not. 8 weeks from the date of communication of this order by the appellant to the respondent number 6, comma, after granting due opportunity of hearing to the appellant, comma, the private respondents and any other concerned party or their authorized representatives. Stop. If it will be up to the respondent number 6 to decide whether or not any physical inspection of the property in question is necessary. Stop. If he deems the same to be necessary, comma, then the parties will cooperate with him in having the property physically inspected. Paragraph, the within 8 weeks bole diyechi na? Stop. The 8 weeks. We make it clear that we have not gone into the merits of the disputes between the parties. The respondent number 6 shall decide the appellant's representation with an independent mind without being influenced by any observation in this order
Or in the order of the single.
or in the order of the learned single judge.
Annexure P3 and P4 not taken by, not accepted before the court because that was.
We have not relied on it also. Paragraph, since we have not called for affidavits, etc., etc.
Yes,
Order and appeal is set aside করে দিয়ে একটা জায়গায়।
yes,
ওটা লিখে দিও। লিখে দিও।
Item number 14.
My lord, 13, my lord, I am paying my lord only 1 day accommodation.
13 কি হলো?
Not today. My lord.
13 not today.
Item number 14.
My lord, I am for the appellant.
I am for the private respondent.
Private respondents and state, no other respondent.
Private respondent, state and my lord Jila Parishad. If your lordship may kindly seize your lordship's last order, my lord. This was, my lord, with regard to engagement of hearing officer in the Jila Parishad, my lord.
Let us read the order.
My lord. এটা তুই রাখ আমারটা নোটিং কোথায় আছে $145 ও ঠিক আছে এটা
মানে কি রে? মানে করে দেয়।
Report District Magistrate.
My lord, may kindly see page 7 of the report. এক, দুই, তিন, চার, পাঁচ, ছয়, সাত। লাস্ট ডেটটা আজকে 21 তারিখ, সেটা কোথায় পেলি?
Oh, today is the last date for submission of application.
My lord, today is the last day. Now, my lord, earlier also your lordship has been pleased to put a specific question that how the hearing officer was engaged initially, what the department has done. Now, my lord, lordship may kindly see page 6 also. Earlier also, my lord, applications were invited. Page 6.
Mr. Vasu,
my lord.
the notice was issued immediately after we passed this order. That is all right. We are not.
But my lord, only I am just trying to impress upon your lordship on earlier occasion also application was invited, but my lord, nobody responded. That is page 6 of the report.
So now, therefore, Mr. Basu, let us not keep this appeal pending.
My lord.
We'll dispose of by clarifying that this process of appointment shall be completed, because today is the last date for application. Do you have any instruction as to whether any application has been received?
No, my lord, that instructions I don't have. But one thing, my lord, I am pointing out, lordship may kindly clarify, lordship may kindly see page 8. Now, my lord, this is also, my lord, the inviting applications online. This is also in the process. Now, it indicates that the end date is 27th of February. Ended 21st February. No, ended 21st.
No, that's child helpline.
Yes, my lord. No, my lord.
That's child helpline.
Yes. 21st.
Hearing officer is 21st.
My lord, that is.
May I suggest to kindly keep the matter pending for at least 7 days?
Who are you?
Private respondent numbers.
It is better you come back with further instruction as to what progress has taken place.
My lord.
Today is the last date for applying.
My lord.
Right?
My lord, only in that case, subject to your lordship's approval, lordship may kindly be pleased to adjourn this for a period of 2 weeks.
Yes, better. Better.
My lord, the interim order may be extended, my lord. And we'll file report accordingly. My lord.
Yes.
My lord.
That is fine.
Read order dated February 6, 2024. Paragraph. The district magistrate, Purbo Mednipur, has filed a report. Invariably, I find, Mr. Basu, these officers will not give a date on the report. I find that very strange. Whenever something is signed, the date should be there. to collector. Without that, he is signed. কি বললাম?
It is 9th January.
No, no, it
Has filed a report in terms of our, in terms of the aforesaid order. In terms of the aforesaid order. Stop. From the annexures to the report, from the report and the annexures thereto, it appears that on February 9, 2024, a notification was issued by the district magistrate in his capacity as the executive officer of the Purba Mendipur Zilla Parishad, inviting applications from government officers superannuated on or before February 9, 2024, for selection and appointment to the post of hearing officer in the said Zilla Parishad, to hear and determine objections in terms of section 160 capital A bracketed 6 of the West Bengal Panchayat Act, 1973. Stop. The last date of making application is February 21, 2024, i.e., today. Paragraph. In view of the aforesaid, as suggested by learned advocates for the parties, let this matter stand adjourned for 2 weeks and be listed again on Tarikhta diye dao. 6th, March 6. Taito, March 6, 2024. Stop. It is expected that in the meantime, the process of appointment of hearing officer in the said Zilla Parishad will be completed. Stop. The district magistrate, who is also the executive officer of the Zilla Parishad, shall file a further report on the adjourned date, apprising us of further developments in the matter. Stop. Paragraph. The interim order that is in operation shall continue till March 15, 2024, or until further order, whichever is earlier.
Grateful, my lord.
Filed a report, let the report be kept with the record.
Number 15.
Please, your
And I am appearing on behalf of Kolkata Municipal Corporation led by Mr. Alok Ghosh.
State respondent.
State.
My lord.
Any other private respondent?
The private respondents, my lord, it has been indicated in your lordship's last order, my lord, that they have been, one of them has been served, one of the envelopes has returned.
What authorities? I've forgotten everything. What authorities you wanted to rely upon? That is recorded in the
Yes,
order.
yes.
On what point?
My lord, on 400 subsection 8.
Oh, right. Yes. Yes, sticky wicket. Yes. Want more time?
No. The time is the thing, my lord, but records has to be produced. I was humbly submitting to your lordship that, my lord, how the, my lord, power has been exercised At least for your lordship, my lord, judicial.
Mr. Banerjee, is it practical in every matter, in thousands of demolition cases?
This is an isolated case.
Section 8, no, nothing is isolated.
Well, it is.
Subsection
With
8.
respect, my lord, there was no 401. There was nothing. Straightway 400 subsection 8 without resorting to, my lord, the 1986 regulations. Whether it has been resorted to, my lord, a honorable single judge of our High Court, my lord, incidentally, my lord, his lordship has, my lord, no longer.
Proceeding was initiated under section 400 subsection 1. Subsequently, it was placed before the Honorable Mayor, and Honorable Mayor.
This runs contrary to whatever has been
Mr.
recorded in the
Chakravarti,
judgment and
Mr.
order of appeal.
Chakravarti, to put an end to the controversy, produce the records. Produce the records.
Yes, very well. Let
You-
the records
you-
be produced.
We'll on the next day, and if we find that the appellant has absolutely no case, you know how we can deal with the appellant.
Only this much. No, act me. Kindly takes the trouble. It had a copy of 2007 SCC online. Just give me 2 minutes.
Let them come back with the
Yes,
record.
yes. Kindly see paragraph 65 once. This is 2007.
Justice Dotto.
Yes.
For that
Look,
time, we have seen this. We have
This
seen.
is the regulation. The exercise of power has to be made strictly in terms of paragraph 65.
This was considered in Nirmalda.
Yes, yes. But my lord kindly sees when your lordship is desirous of records, my lord, if for your lordship records, if this entire exercise has been complied with, my lord, an affidavit within 3 days may suffice. They have decided to exercise 400 subsection A.
We will look into the records.
As your lordship.
Certiorari jurisdiction
Very
is
good.
there. Produce the records. Mr. Bhattacharya, the appellant's learned counsel says that there's nothing on record to show that Kolkata Municipal Corporation followed the statutory provisions in invoking the emergency power of demolishing the impugned structures without granting opportunity of hearing, under section 400 bracket 8 of the KMC Act, 1980. Paragraph, since we are exercising certiorari jurisdiction, let the corporation, let KMC produce the relevant records of the case on the adjourned date, including the resolution of the mayor in council.
Mayor in council resolution may be there. Let us assume, whether the procedure envisaged by
We
law.
submitted our report before the
114 is Mr. Bhattacharya.
No, with respect, no.
What?
In this matter, no report was filed. I invited your lordship's kind attention to the previous order made by the court at the instance of the complainant, where it is recorded, 401, your lordship, Justice Muralidharan will kindly, recall, I showed your lordship the previous order made by the court.
Or you can also do this. You can file a report annexing the relevant document, copies of the relevant documents.
Lordship.
That is, what would you prefer?
We will submit report.
Since we are exercising the KEDRA, let KMC file a report to a competent officer answering the aforesaid grievance of the appellant and annexing to the report copies of relevant documents, and not notice. What notice? 400 subsection 8, what notice will be there? Relevant documents showing that due process of law was followed.
Was done.
Due process of law was followed. Ajay, list the matter on 1 week.
Weeks. 2 weeks.
He'll be glad if you take 3 weeks because
2 weeks, 2 weeks, Lordship. ওদের 18 মাসে বছর।
very well. Don't take 2 weeks, 10 days.
Very
10 days. This the matter once again on ওটা করে দাও।
But in the meantime, it is understood no coercive measures will be taken.
We are saying nothing because interim order has not been passed. We are saying nothing.
And in the meantime, they should not do anything to
You go out and tell Mr. Chakraborty.
On behalf of the state, we have the report filed on behalf of the concerned police station, Lordship. May I file this report, Lordship?
Did we call for a report?
No.
File it.
some balance has to be. If it comments to your lordship,
Absolutely no sanction plan. It has been once refused by the other bench.
That's the honorable single. Therefore, we are in appeal.
No, not single bench.
Division bench.
Honorable Justice Shomensen.
Justice Shomensen.
Honorable Justice Shomensen. Division bench of
Thou.
Division bench of Honorable Justice Shomensen.
Yes, that's what
it
I'm
was
saying.
refused. Prayer was made.
That was on withdrawal,
withdrawal.
I may be wrong, কি বলছিস রে ভাই? বলিস না।
Interim order.
Yes, you were not present.
Interim order was prayed for and it was refused.
Rajanot.
I can hear the shouting from that.
You can hear the কি মানেটা কি?
Everywhere. Normally I am playing because of shouting. But when I remain silent, then I hear the shouting of everywhere.
Item number 60.
একাদশ অধ্যায় of Gita. Do you know what that is? Vishwarup Darshan.
Some colleagues in the parliament, irrespective of the party, sometimes ask me, Dada, why you have become so much silent? Why you have become so much quiet? I say them to hear all of your shoutings.
All, yes. You are for?
For respondent number 426, municipality. Raghunathpur Municipality, Purulia.
Service is complete, Mr. Bandyopadhyay?
Including the state is also.
State is appearing. Who is the answering respondent? Municipality?
State.
State. You serve the state.
Yes, yes.
This is the problem. You served on the GP's office. Never.
GP's office only has
I know, but then who appeared before the learned single judge?
You will come at the time, at the last stage of the hearing. He will enter, but at the last stage of the hearing.
Let us read the order once.
Yes. From the memorandum appeal, your losses wants me.
Memo from the memo. Mr. Mondol, why don't you go out and try to call Mr. Tapur Mukherjee?
I had called Mr. Mukherjee before the matter was taken up by your lordship. He said that he has not been given the brief by the GP's office till now. But my lord, Mr. Somnath Noskar is there along with Mr. Mukherjee. I had even called him up. He said that he has received the brief, he will come. That is what was intimated to me.
No, today little scope is there, I just tell you, so that will not create. But earlier two writ petitions were moved by one of the unsuccessful candidates and one of the councillors. That two writ petitions were dismissed by this court, affirmed in the division bench also. I mean, third round of litigation started by one unsuccessful candidate again. Then one of the single judge has directed, long after, 4 or 5 years after, to make an inquiry into the matter. While inquiring into the matter, director has passed certain order which is going against us. Initially, very cryptic order. But against that order, when the Learned Single Judge third matters passed an order, we preferred an appeal. Appeal was pending. But when that order was placed, order was passed, it was placed before the Honorable Division Bench. The Division Bench observed that since an order has been passed, liberty is given to move before the appropriate. Naturally, Miller, another writ petition was filed. When it was filed, saying that this cryptic order, then without having any directions of the High Court, Miller, the show moto of the director has passed an order. That has been challenged in the writ petition. Your lordships have gone through the writ petition. The Learned Single have passed the order. Miller, there are 2 or 3 fold submissions I will be making. First of all, Miller, one of the most important grounds has been taken by in the second order, which is impugned, that the outside agency has been inducted. Miller, outside agency was not inducted by us. That was, Miller, your lordships will find it from their letter from 166, that they have said, this is the deputy director has said, (166) kindly see. Office of the Deputy Local Bodies, 10th February, to the Chairman, Raghunathpur, not Asmans Miller, not the municipality. To the Chairman, Raghunathpur Municipality, observation of so and so. You are here requested to engage the above said agency for recruitment of different posts of the Raghunathpur Municipality, as the said agency given their best services in different municipality. Therefore, this is the municipality. We appeared, municipality has engaged on the basis of the state government's direction. Now, why? Because of the third persons who are unsuccessful, you are saying, no, this cannot be done. This is one of the aspects of the matter. Second aspect of the matter of the Miller, in the orders, your lordships will find that some things are missing, some things are missing. These have not been produced by the Raghunathpur. But the Learned Single Judge did not at all consider, Miller, with great respect to this order, Miller, the Learned Single Judge didn't apply his minds at all. No reason has been given why my case is wrong, why the municipality stand has not been accepted. If your lordships kindly come to page, Miller, the municipality's affidavit, it starts from page 127. And Miller, annexing all documents there.
What is the municipality stand?
Stand is that everything is all right. Stand is that we have given this advertisement was made.
The DLB's order was challenged before the Learned Single Judge.
DLB, what has happened? DLB's order was challenged. This is in a third instance. Kindly, 2 batch of writ petitions had been, they came before this, they became unsuccessful. These writ petitions were dismissed. Then the third, again, another third person was coming after 3 or 4 years. When the 3 or 4 years, after 3 or 4 years,
you are the writ petitioners in the present
yes, then the one of the single judge has passed an order to make an inquiry into the allegations. In the third writ petitions, that against that we preferred an appeal. Leave, because we are not parties to the matter. Leave. When this appeal was pending, Miller, the report on the basis of an inquiry, an order was passed. Your lordships kindly find from that. This is your lordships will find that first kindly similar 103. This is the report, 103. This is the report was filed, Miller, when the pending before the division bench. In compliance with the order of the Honorable High Court, so and so, the Director Local Law, so and so, The inquiry has been conducted by Director of Local Bodies, West Bengal and ex-officer of Urban Development and Municipal Affairs Department, and report dated has been submitted. The chairman Raghunath Municipality was requested visit this department letter number to submit their comments with supporting documents within a week. The reply of the municipality has been received on 20th. Considering the urgency of the case, the municipal authority and the inquiry officer requested Mr. to attend a hearing with original documents relating to the case. After examining the replies of the giving them reasonable opportunity. To whom this reasonable opportunity was given? To municipality and the persons who have filed the writ petition earlier, not us. To explain the recruitment through examination of documents related to recruitment, the department is of the view that the panel prepared by Raghunath is not acceptable to the state government, as the same is not to be found in order as per recruitment and norms of such the state government intend to cancel the panel and direct municipality to initiate phase recruitment process. Right? When it was placed before the appeal court, appeal court passed page order at page 106. Can you see? Having heard the second part of having heard the learned report for the party, we have the view that both the appeals and the can be disposed of, granting liberty to the parties to move the appropriate forum in the event they are agreed by the report of the secretary to the government of West Bengal. And this has happened, Millard. Now, when this has been challenged in the writ petition, there will another order. Now, there was no scope to pass any order by the state government. Now, another order was passed. Kindly come to Millard, that is at page 114. 114. It starts from 114. Now see, all that will are 214, your lordships will find the names, address, all are unsuccessful candidates. We have never heard. Now, Millard, kindly come, Millard. Now, there is no scope. Read Millard 117. In compliance with the order of so-and-so, read with so-and-so, development was directed to make an inquiry. The inquiry has been conducted by the local so-and-so, and a report has been submitted. The chairman was requested by this department letter number so-and-so. That is was under challenge, and the grounds which have been given from 118, that has been just set out by the learned single judge. And thereafter, matter has been dismissed. Now, to that extent, Millard, kindly see the Raghunathpur municipality's affidavit. That has not been considered at all. Our submissions have not been considered at all. I know, Millard, this is at this stage. What can I make the prayer? Because it has to be hard out. Appeal has to be hard out. Millard, what I am praying today is this. Before dismissal of the writ petition, Millard, there was an interim order. That is at page 126.
Impugned order is dated
Impugned
8
order is
January.
dated
8 January.
1st November.
So there was for 6 years you enjoyed an interim.
Yes. 5 years.
Maintain status quo.
Huh?
Yes, sir. 6 years they've enjoyed an interim order. Let status quo be maintained. We'll hear out the appeal, file
Yes,
informal paper books.
Yes, sir.
See, Mr. Mukherjee did not come.
My lord, I just want to mention one
আর কি
thing.
দরকার আছে বাবা mention করার? এখন কি দরকার নেই?
Issue. This appeal is directed against a judgment and order dated January 8, 2024, whereby the writ petition of the appellants herein, being WPA 3856 of 2018, was dismissed by a learned judge of this court. Paragraph. The writ petitioners approached the writ petitioners were successful candidates in a process for selection to various Group D posts.
CND.
CND.
Group C and Group D posts in Raghunathpur municipality. Stop. They were impaneled. Stop. Subsequently, the panel was scrapped. Stop. Being aggrieved, they approach the learned single judge. Stop. Their writ petition having been dismissed, comma, they have come up in appeal. Paragraph. We've heard Mr. Bandyopadhyay, learned senior advocate appearing for the appellants, oblique writ petitioners, and Mr. Sir, your good name is? Shamanto. Mr. Shamanto, learned advocate for the municipality. Stop. In spite of service, the state is not represented. Affidavit have you filed?
Yes, my lord.
প্রথমে affidavit of service টা নিয়ে নিও। Paragraph, we are of the view, and Mr. Bandyopadhyay agrees that the appeal has to be heard out. Stop. Let requisite number of informal paper books be prepared by the appellants containing all papers that were available before the learned single judge, within
Any day,
Within
subject to
2 weeks?
Yes.
Within 2 weeks.
2 weeks from date, Tariq to the March 6. Stop. Since the municipality is represented, notice of appeal is deemed to have been waived insofar as the municipality is concerned. Stop. Let notice of appeal be issued to the state. Stop. All formalities are dispensed with. Paragraph, list the appeal under the heading specially fixed matters within the first 5 items. 3 weeks since, 2 weeks since, what? When?
I'll not be able to come.
When will you be able to come? Tell us.
স্যার আপনি যবে আসতে পারবেন সেটাই
জুন বলতে হবে তো।
বলুন, তাই বলুন স্যার আপনি
Whenever.
In the month of June.
Huh?
In the month of June.
June.
Notification will be issued, no?
We have no problem, but
Anyway, lordship kindly direct the matter, let the matter comes in the list of the April, then we'll see.
Yes.
That's
in the monthly list of April.
Then we'll
ঠিক আছে? Among first 5 items in the monthly list of April. Paragraph. We see that an interim order was passed by the learned single judge on a Dittani, page 126. What is
126, my lord.
1st November 2019.
126, page 126.
1st November?
Yes, sir.
Sure.
Yes, yes. Your lordship, the date is not there because it is there.
Interim order on November 1, 2019, directing the parties to maintain status quo. Stop. Since the appellants enjoyed such interim order for a long time, let such interim order continue to be operative till the disposal of this appeal. Till the disposal of this appeal. Let such interim order stand reinstated and continue till the disposal of this appeal. Paragraph, the stay application stands disposed of.
My lord.
Stop. However, a copy of the stay application be included in the informal
In the
paper book.
informal paper book.
We'll do that.
That is better. Deeply obliged.
Deeply obliged.
I have completed 20 years in the parliamentary democracy.
20 years. Sometime, maybe after I retire, we'll sit with you and hear your experience.
Oh, sure, I will give it. I will tell. Interesting. Interesting. Really interesting too.
You should pen down your experience.
I will pen down, but when I will pen down, thereafter I will retire from profession and politics. Because it will be more very controversial, both for judiciary and politics also.
Don't retire for the next 5 years.
No,
Let
not
me
5
retire.
years. Not 5 years I am here, but that after that.
Very well.
But I am not willing to continue much years. Within 75, I will. Dr. Banerjee has given us a very has shown us a very good pathway. After 65, close everything. So we couldn't do it within 65. Development.
Item number 17.
Mala, I appear on behalf of the appellant. So, my lord, this Gram Panchayat, my lord, is required to present. Because of that, I have challenged the my lord, this come before your lordship with regard to my lord the unauthorized construction on my lord's Salila. So, if your lordship subsequent during the pendency of this appeal, the Panchayat has served the my lord the certain my lord the document with regard in support of the claiming to be the
1 second, sir. Allow us, Mr. Haldar. We have recorded this facts, the facts. Let us read it.
What's your answer? What is it's the DOJ. Look. Thank you.
Affidavit in opposition filed. State's report you have got now. Yes.
My submission before your lordship, my lordship, if your lordship kindly come to my affidavit in reply. Subsequent development which has been my lord given by the Gram Panchayat as well as the my lord the state, I annex the document. I am only relying.
Yes, Mr. Haldar, we had directed the state to file a report and produce 6 documents.
Only my lord, they have not my lord the produced before your lordship. The
Who is for the state? You are for the state.
Only one document, but that document is also not necessary. Because of that, they have submitted the my lord the report of the DLIT. So DLIT report will come after my lord the making an application of the alleged my lord the madrasa. Then the question of the report will come. So that report, I am my lord relying the report which has been placed by the state before your lord, submitted before your lordship. That is the only report. That report is sufficient to my lord argue my case before your lordships.
Yes. This is the report you filed.
My lord.
This is the report.
My submission before your lordships, whether any construction made by the can be made on a Sali land or not. So now it is the settled by your lordships also division Falguni Mukherjee judgment. So Sali, unless and until the land is converted to the Bastu in compliance with Rule 17 of the West Bengal Gram Panchayat Administration Rule, the no sanction plan can be granted by the concerned Gram Panchayat. If the land, it appears that the land is Sali land, the Gram Panchayat, it is the under obligation under Rule 26 to withhold the permissions. Now, here in the case is this, by taking advantage of the recognition granted by the concerned department. So now they have constructed the building another plot of land. Madrasa has been sanctioned in a particular 733. I am not concerned about the 33. By it appears from the report of the DLIT. In the official record, that is also appeared that the madrasa which had been granted by the authority concerned in plot number 733. Now, after getting the the recognition, it is not the madrasa at par with the that has been under the scheme. That is the Madhyamik Shiksha Kendra. The school living student will allow to the participate or to admin in that school. So they are the teaching and non-teaching are getting only honorarium, not salary. Here in this kindly come to page the report of the learned pen who has been submitted, the DLIT report. Lordship, kindly come to page 13 in my affidavit in reply. The report which had not been. Page 12 is the report of the district level inspection team. That report which has been submitted by the authority concerned on the basis of the application made by the unrecognized madrasa. Page 12 start the date of inspection, the 29th of June 2010. Got it? Top right corner, my lord, the date. Now, second, my lord, is a kindly come to next page. Page, the plot number which has been mentioned, that is, my lord, is a left-hand corner, my lords, the Roman 6. 733. Now, the madrasa consisting how many buildings, how many rooms is there? The total definition which has been made by the DLIT district level inspection team, total number of rooms 14. 14. Rooms total square feet which has been mentioned. Now this is the very vital is the plot number. I am not concerned about 733. So now the report which has been submitted by the district level inspection team, that is kindly come to page 15. The recommendation has been made in 2010, and on the basis of the recommendation, the school has been recognized. And the surround of the school, that is page 15, well, the definition is there. The school is required. How many distance another school is there? Kindly come to page 15 in the box, my lord.
How are these relevant?
My lord.
These related board, my lord, they do not have any problem. How are they relevant?
My problem, my lord, my learned pen is highly manufactured document. I show people, then they export it. Now, relating is this, that madrasa is standing, existing in the plot number 733. They have taken advantage of that recognition, constructed 630, plot number 630. And after that, I have been problem. Because of that, they are trying to use my land. That construction on my lord, this Sali land.
Now raising a civil dispute which was
no, I am not. Whether the let me finish, my lord.
Completely, my lord, new documents have been annexed.
No, my lord. Kindly come to now. They have got the sanction plan. Kindly come to page 80. That is very vital, my lord. Is the they made an application. It appears from the document. Made an application 20 November 2013. So now, if your lordships kindly come to rule 17 of the West Bengal Gram Panchayat Administration rule. West Bengal Gram Panchayat Administration, when the sanction for the granting sanction of the building, kindly come to the rule 17.
No, what document you for the first time annexing to your affidavit in reply? What kind of thing is this?
During the when I moved and petition,
did you disclose this document earlier?
They have disclosed before the learned single judge. I have not been given an opportunity to controvert that document. On the basis,
This page 18.
yes, 18, 19 onwards. Nothing has been allowed to, my lord, controvert that document. It appears from the document is manufactured.
The sanction
No, but
plan,
let him finish. Let him finish.
only because the sanction plan we have produced before the learned single judge.
My lord, kindly come to rule 70.
Read it out.
My lord, this the my lord, the control of building operation. Subject to the provision of Rule 20, any person intended to erect any new structure or new building or to make any addition to an existing structure or building in any area within the jurisdiction of the Gram Panchayat shall, for obtaining prior permission in writing of the concerned Gram Panchayat, make an application in duplicate in Form 4 to the Gram Panchayat. The secretary or any other employee of the concerned Gram Panchayat authorized by the Pradhan in this behalf shall receive the application in duplicate, retain one copy of it and return the other copy, nothing therein, on the date of receipt under the signature of the said seal of the Gram Panchayat. Now, second, provided that if the erection of new structure or a new building or to make any addition to existing structure or building is for setting up an industry or other than the industry, I am coming by the rule 72. 2. An application in Form 4 shall be submitted along with a plan in duplicate. Plan is required to submit before obtaining the sanction plan of the proposal structure or building, a site plan in duplicate, copy of the records of rights in the name of the concerned intended applicant. It appears from the application submitted on 23rd of November 2013. As on that date, land is recorded as Sali. First, and they should submit the sanction plan. Here in my lord, I am annexed the document which has been produced before the learned single judge and also during the pendency of this petition, sub the Gram Panchayat. The submission of making application on 20 November 2013. My lord, this the 2013 they made an application. Done permission granted 9th of January 2014. Sanction plan, my lord, this proposed building plan prepared after granting the sanction. On the record, on the face of the record, they are submitted. Kindly come to page 19. So now 4 criteria is required at the time of making application for granting permission. If not those documents submitted by the intended parties or applicant, then the withhold under the rule 26 of the Gram Panchayat. Now, my lord, kindly come to page 19. Page 19. Date of communication by the concerned Gram Panchayat, 9th of January 2014. And it has been categorically stated, I think that this document is manufactured. Because I have been communicated during the pendency of the writ petition, Pradhan says no sanction plan has been granted by the Gram Panchayat. That document I have annexed during the pendency of the. Now, second submission. Now, the Panchayat took a decision on 29th of November 2013. The site plan which had been submitted 3rd of January 2014. That after that, law says that at the time of making application, you should submit the site plan. Second submission before your lordships, as on the day, the land is recorded as Sali land. That is the agricultural land. And name of the different persons. I am not disputing the title. He may be owner, but land should be recorded as a, my lord, this is the pastu land as per the rule 17. If those documents is not available, it is the duty of the Gram Panchayat to withhold the permission.
Assume the Gram Panchayat has wrongfully granted permission to construct on Shali land.
Shali land.
What will be the effect?
Effect lordships held, my lord, the Phalguni Bandobadhyay, that's Phalguni Mukherjee judgment, division lordship.
Like proceedings under the Land Reforms Act? Initiate proceedings?
No, that part, that ex passio, that sanction, if it is not the sanction in the eye of law, lordship has the power to set aside, to declare that is the sanction is nullity. Lordship has the power because of the on the
show us Phalguni, yes. from,
Falguni Thakur.
for the last half an hour, you're saying Falguni. What is it?
So, my lord, this is the Falguni Mukherjee judge.
Show us which portion you're
My
relying
lord,
on.
this paragraph 7, 8, and 34. My lord, may I two documents? My lord, two.
Give us, we'll read it. You don't have to place. Give us.
Yeah, I am giving that. No, no, MAT 10-1025 of 2022. My lord, another copy I have. I have no. My lord, I am giving the marks. Your lordship.
7, 8, and 34.
Plus, I have given top, my lord. 1025. Paragraph. Another
This is authority for the proper, anyway. Yes, anything.
another judgment is the same point. My lord, is if the authority, sanctioning authority is found the land is recorded in Sali, another division bench held, Rule 26 has to be complied with. My lord, this the
Mr. Haldar, we want to know from you and you are not answering us. If construction is made on Shali land without due conversion, then what happens? Must the building be pulled down? Or proceedings under the Land Reforms Act will
I
be
am not
initiated?
paying before your lordship as on today, my lord, I am not paying for pull down the proceeding under section 4C of the West Bengal Land Reforms Act. That has been held. I am coming before your lordships that building is unauthorized construction. That building should be demolished.
Oh, there is building sanction plan. Why do you?
What sanction plan? Kindly see that, my lord, another division page. This is not the at all sanction plan. This is not at all sanction plan. But the sanction plan is void ab initio, my lord. That has been held another division page, my lord Justice Soumitra Pal and my lord DK said, then held lordship, then my lord, this is the another deputed judgment.
Whatever you want to cite, Mr. Haldar. We'll pass our order.
My lord, no. I want before your lordship only laid down the certain, my lord, the provisions. Even it is the construction has been made on
Very well. Come back tomorrow.
lordship. Only, my lord, I have come with the short notes, my lord. I will come a short, my lord.
No,
But
no.
that is required because
No notes required.
my lord, this the otherwise, my lord, this the I will, my lord, I whatever, my lord.
May I come back, my lord?
When?
2 PM today. Because tomorrow, my lord, Justice Ajay Kumar Mukherjee has fixed
Don't be on this original side. How will you come back?
an appeal tomorrow. Friday.
Friday? Heard Mr. Haldar, comma learned advocate for the appellant. Stop. He does not conclude. paragraph as requested, comma, list the matter once again on পরশুদিনের date দিয়ে দাও, comma, for further hearing.
Panchayat is required because of the document which has been, I am now disputing that document is manufactured. Panchayat,
The more you dispute, the more it takes out of the writ jurisdiction.
no, they are submitted, I am not allowed to controvert.
So therefore, you are allowed to controvert, certainly go and file a civil suit.
No, civil suit is the they already there.
And if Millard,
File another suit.
if he doesn't want to demolish, then what is the purpose of this litigation?
I want to demolish.
এখন তো বললে করবে।
আমি
Original.
May I pray for a leave to move an urgent review application before Lordship? But we have
This
not-
bench.
Yes. Well, the certified copy was not yet obtained. Well, because the order was passed on 9th and the order was
9th of February.
9th of February, and it was uploaded in the website on 16th.
কেন বাবা এত দেরি?
Because I hope, my lord,
সরস্বতী পুজো etc. I think.
because the my lord was not in.
Oh, acha, acha.
Maybe that's the reason.
Yes, without certified copy.
Without such. This is appellate site. That is another
Oh.
technical problem, but the officer is there. We have a talk. I'm grateful.
Original site, item number 1.
In this matter, I am appearing for the Kolkata Municipal Corporation respondent.
I am also appealing for the private respondents under the petition.
I am also appearing for the. So far, I have not received any copy of the stay application, either of the memo of it.
Mr. Mitra, what happens normally your client is served. Your client may not have given you. If they,
That is possible.
anyway, the appellant is not there. We'll pass it over as we do.
Then, kindly keep it on Tuesday, my lord.
Tuesday.
I'm led by Mr. Sumitabo Chakraborty.
Mr.
For the Sumitabo Chakraborty. Petitioner. Appellant. One of the
He is not well, we are told.
Yes, yes. His father expired.
His father expired.
Kindly keep the matter on the 5th March.
5th March.
Oh, very well.
Very well.
The appellant is
But
not
in the
represented.
meantime, what I am praying for one another thing. There are 2-3 reports filed before the Honorable Writ Court.
By you.
Yes, my lord. Pursuant to a direction of the Honorable. My lord, those are not before this Honorable Court. Let the LCR be called for.
Writ petition is disposed of.
Disposed.
Yes.
The appellant is not represented. Stop. Paragraph, learned advocate for private respondent number.
I'm 5. This one number
5.
4. Single bench lordship 6 respondent number.
Here is
But
the
we
appeal
don't
you
receive any copy lordship.
for one of the private respondents. For one of the private respondents says that he will not learn an advocate. Says that the arguing counsel has suffered a bereavement. Stop. He requests that the matter be listed again on March 5.
Yes.
Paragraph. Mr. Mitra appearing, learned advocate appearing for Kolkata Municipal Corporation,
Private
says that it may be necessary for the records of the writ petition to be produced for more convenient adjudication of the issues involved. So, let the records be produced. Let the records that were there before the learned first court be produced before us on the next date. List the matter on March 5.
I'm also appealing for one of the private respondents. But in the meantime, I have informed my client that they haven't received any copy of the memo or the application.
5th of March, before that you may be.
Get to me.
Item number 2.
We brought it up in the list because it was not being called on, being at the bottom. Before we forget the matter.
Yes, I'll finish off today. I'll not take too long. The only question is whether I should carry on till Mr. Ghosh comes back. He has gone to do a matter which involves some rare elephant, I'm told.
Rare elephants?
Yes. FPIL to do with the hijacking or kidnapping of an elephant. That's what he was telling me.
I am very fond of those creatures. Personally, I am very fond of them. When I was in the first court with the Chief Justice, which I was for a long time.
Yes. Many Chief Justices.
Yeah?
With many
Chief Justices. So we had the occasion to entertain many such PILs relating to wild animals. And I took special interest in elephants. Anyway.
But there are a lot of PILs to do with elephants. I hadn't realized that.
Quite a few.
Yes. One I know was a case of Andaman elephant, my lord. That one I remember having. Kerala has a lot of.
Madras, one advocate by namely Rajendran filed several pill cases in respect of elephant. Finally, his name found Elephant Rajendran.
He's lucky it was only elephants. But if it had been some other animal, tiger would still have been all right. But there are others, not like not pigs and other such things. Not. I can see Mr. Shubroto with grey hairs. He was very, very young when we were young also. But this morning we were discussing, Mr. Mitra was, Arijit Mitra, he was showing us some photographs. And well, there's some good news in his family. So, so that's why he was showing us some photographs. And I said, well, you look younger than the prospective father-in-law. So he said, no. Well, I say, well, at least in the photograph, yes, but not then. We look at each other, time has gone by, we don't realize we've gotten older. In the mind, that old photograph is still there.
You don't grow old, your body grows old. Well, let's come back to Binaguri.
Well, I'll keep it very short, not because my learned friend has cited not as many as perhaps 14, 15 new judgments, but I don't really need to take care of it. I'll try and not distinguish it on principle. But I'll just not take 10 minutes to summarize what his arguments had been when he opened the appeal, what my arguments were, and how he has dealt with it in appeal or not dealt with it in his reply. But because most of our arguments have not really been taken care of is what I intend to show. So, my lord, your lordship will recall, my lord, my learned friend argued basically 2 points when he opened the appeal. Lord, one was, my lord, that it's a suit for land. That was his principal point. And number 2, my lord, he argued it on merits also to say that, look, I am not the owner till I establish ownership. I have no right to get eviction. So, my lord, those on merits again. Now, my lord, my principal point, if your lordship remembers, not in reply, but I have summarized his argument very briefly, but these were the 2 points that he had argued. At that stage, he had not argued limitation, although in his reply, he brought limitation also into the picture. Now, my lord, my principal argument, if your lordship remembers, were basically not 5. Number 1, all of this is beyond the scope of the application which was before the court. The application was simplicity. Commission. And that too pre-COVID. COVID over, we said, look, now I'm willing to come into the box. So, scope of the application was very limited. But if within the scope of the application he chooses to argue everything, and the learned judge doesn't decide it, will it give him a ground for appeal? But in my humble submission, it won't. Because number 1, my lord, it was beyond the scope of the application. Number 2, my lord, your lordship has seen not the question of the 2 points he is raising, not today, jurisdiction and ownership, could not have been decided within the scope of that. So whether there is any finding or no finding still will not matter. Now, my lord, to that, my lord, no answer is really given. He tries to meet it when not meeting the point of appellability, but it still does not meet my argument that, look, all this is beyond the scope of the application. Now, my lord, number 2, my learned friend kept saying that, look, the suit has to be decided as a suit for land on the basis of the averments in the plaint. Now, my lord, I have very little, quarrel with the proposition that a demurrer must be decided on the basis of the statements in the plaint. But not was it open to him to argue it in the course of that application? Number 1. Number 2, Lord, he could not have argued territorial jurisdiction, Lord, as a defense in that application. I tell your lordship why. In a Order 7, Rule 11 filed by him for dismissal of the suit on the ground that there is no jurisdiction because it's a suit for land. But the court has already decided. Your lordship has seen the orders. His Order 7, Rule 11 on the ground of revocation of leave under Clause 12, dismissed 20 years ago. Now, could he have then said that, look, now you decide it on the face of the plaint?
Dismissed with the observation that it will be considered at the hearing.
Correct.
As a preliminary.
Correct. So therefore, my lord, can it be taken at this stage?
You say at in this res judicata principle operates at the different stages of at these of a suit.
Of at least the interlocutory stages. Yes. Not at least the interlocutory stage.
He cited a judgment on that, I think.
Yes. Now, my lord, please not bear in mind, was this argument open to him at all now? Once his Order 7, Rule 11 is dismissed, where he took the same point. Lord, it means that and it went all the way to the Supreme Court. It means that the court has come to the view that it cannot be dismissed on the basis of the pleadings in the plaint. No, that is decided once and for all, that by reading the plaint, at least it cannot be dismissed on the point of jurisdiction. You may dismiss it at the final hearing, but by reading the plaint, it cannot be done. Now, your lordships have seen those orders. If your lordship wants, I can place it again.
No.
But not the orders are all there. Order 7, Rule 11, specific point of territorial jurisdiction, suit for land taken. Court felt that it cannot be dismissed by reading the statements in the plaint to be true and correct. That has been upheld all the way to Supreme Court. So, this argument is not open to him. He has spent 3 days arguing this. I don't want to say anything beyond that. But for me to now start dealing with suit for land, that question does not arise. The point is taken care of for good till the trial of the suit. I won't say for good, but till the trial of the suit now. And this attempt to take the same defense, again and again and again and again. I've showed your lordship the order. We have placed a list of dates. This is an abuse of process. And I had invited your lordship to come to give me a finding on this. Because your lordship will remember, after dismissal of this, they filed an application. Now, on the ground of suit for land, there was no application by them saying treat it as a preliminary issue. But on the ground of limitation, after this application was allowed or not allowed, they filed an application asking for fixing a preliminary issue on the ground of limitation. No such exercise for the case of jurisdiction. Please bear it in mind. Now, I've been hit with that. That application of theirs has also been dismissed. There's an appeal pending against that. This same defense has been taken time and again and again. Although the courts are repeatedly saying, look, this is now decided. Now, the next point I'd argued, this was the second point. The third point I'd argued is the findings in the order can't be faulted in any way. What are the findings in the impugned order? That there are earlier findings on several points. That's what it says. Number 2, it says that there is no application for revocation before the court. So can the court, in a roundabout way, now say, look, by reading the plaint, I'm going to dismiss the suit in the course of hearing a commission application? So that's the third finding there. Fourth finding is that the application is now redundant, because I've said I will come into the box. So the learned judge records that the application is redundant and does not grant relief on it per se. In addition, the only other thing that this order does is it fixes the suit for witness action. Now, it can't be faulted because there are already 4 prior orders of the court fixing a date or saying that the suit has to be heard. So all that he's done is fixing a date. So the order can't be faulted, and my learned friend has not pointed out any such order which one can say is perverse. He cannot say that the order is perverse, and that's the only ground really for setting it aside, other than saying that, look, it's without jurisdiction. The impugned order does not allow the application, it only fixes a date. And that fixation of date is not in accordance with several orders, including orders of 18 January 2016 and 17th of March 2016. It does not decide anything finally, which brought me to my next point, which was that of appellability. Because
elephants have been dealt with. Elephants have been dealt with.
Oh, oh.
The side will bring the brief.
Very happy.
I told my advocate on record that pro bono takes precedence. He offered to make this pro bono.
But I don't think Mr. Ghosh at least has been hit with this one earlier.
That was suicidal, Mr. Ghosh.
Like I told him, he asked for it. So now he's sitting pro bono today. You've told the court now. So that brings us to the point of appellability. If there is no finding and the application is not allowed, mere fixation of a date is not appellable. And I had cited two judgments on this point. Shah Babulal Kimji's case and Shamsel, which is the later judgment. Now, that point I take care of maybe in 2 sentences again. My learned friend, to get around it, cited Liverpool to say that, look, an order refusing to reject a plaint under Order 7, Rule 11 is appellable. Maybe. But not in this case. How does it have any application? This was not an application for rejection of a plaint under Order 7, Rule 11. So how does he apply that principle here? There's been no rejection of Order 7, Rule 11. One has seen many days of learned arguments and 4 judgments on the point of appellability. But where does it meet my point? That look, a date fixation is not appellable. Nothing of any moment has been decided by that application. The application simply says, look, let the suit commence for hearing.
Just as a matter of interest, is an order rejecting an application for appointment of commission appealable? This decides no right of the party as such.
As I understand it, maybe the way that is these issues dealt with. Of course, I can't give your lordship any judgment on it without looking it up.
Academic, purely academic.
Yes, but it would be this: if the order of appointment of commissioner is without jurisdiction, then it may be appellable.
Right.
But if the allegation is not that it's without jurisdiction but within jurisdiction, but the order is erroneous,
refusal to appoint,
maybe because if a person has a right to have appointment of a commissioner, for example, a preliminary decree of partition has to be done by a commissioner, then his right has been rejected because the final order of partition may not take place thereafter. So I can't say I'm 100% sure. It needs a little bit of looking up. And so order for the revision.
Yes.
So the point here is Shah Babulal Kimji says simply this. Let's put it this way. It draws a distinction between 2 types of orders. The type of orders which merely help in progress of the suit. Interlocutory orders which help in the progress of the suit. Written statement, this, that, dates, etc. And those which decide things and affect rights of parties. Finally, those are judgments and would be appellable under clause 15 of the letters of patent. But those which don't decide any right finally or affect the rights of parties, but are merely orders helping the progress of the suit, those are not appellable. That principle is clear from Kimji, followed all the way till now. That principle has not been disputed by my learned friend. He simply shows a judgment, Liverpool, look, Order 7, Rule 11, rejection, appellable. Now, is that the point in issue over here? It's a complete bogey. Point here is, look, you took a defense, the defense is not accepted for the purpose of throwing out my application for commission. Now, in this case, that too is not allowed because my witness is now there. Court says bring him into the box on a particular date. That can't be said to be dismissal of Order 7, Rule 11. So I don't see how Liverpool helps my learned friend's case. One can then not get into it and I can argue appellability for a long time. But the point is it has nothing to do with our matter at all. So, my lord, that was on the point of appellability. Then, my lord, now, my lord, as Mr. Ghosh points out, that application does not decide any right, whether finally or otherwise, nothing. A date had already been fixed, my lord, earlier. The court has simply gone ahead with it and fixed a date. Now, is it my learned friend's contention that the court did not have the jurisdiction to fix a date? I have not heard him say that. So, my lord, if it's not a jurisdictional issue,
that's his point. Point in defense does not have jurisdiction to do anything.
To do anything. But the point is, my lord, the Order 7, Rule 11 on this point was rejected, which said that, look, the court will continue now. The court will continue right up to the trial. That's not been disputed by my learned friend. So therefore, my lord, it's not his case that the learned judge did not have the right to fix a date. It's not his case that the learned judge had no jurisdiction to fix a date. His case is simply that, look, he should have again once more read the plaint and decided that, look, I have to dismiss the plaint as it is. It is not necessary to go into the evidence. Now, my lord, to put it bluntly, that has been decided. It could not have been urged at all. But let alone before, my lord, the appellate court, it couldn't have been urged before the my lord, trial judge himself. Otherwise, my lord, it makes a mockery of proceedings. At every stage, I make the same argument. I file Order 7, Rule 11, it's rejected. The court says, look, that can only be decided on evidence. Then, my lord, can I keep on taking that same defense again and again and again? Lord, which brings me to the last two arguments which we had made. Lord, your lordship will remember, Lord, there has been an amendment to the CPC, Order 14. I cited the judgments which say that before the amendment, there was a mandate on the court to decide the preliminary issues first.
Yes.
Post amendment, the court says, look, that mandate is gone.
Yes.
Number one. Number two, it's discretionary. Number three, in applying that discretion, the court will try and answer all issues together. Why? Because it shortens proceedings. It ensures no multiplicity of proceedings because, for example, if a court only decides the preliminary issue, matter goes up in appeal. The appellate court sets it aside. It goes back. Then, Lord, again, evidence will have to be taken. And that's the exact observation. ওই দুটো জাজমেন্ট গুলো পাঠ করবো ওই রমেশ দেশাই আর ওই সত্যনাথ পাঠ করে নি But two judgments were cited by me on this. Lord, your lordship will remember Ramesh Desai's case and Lord, it later 2022 case. Yes, I've got it. Lord, please, Lord, if your lordship would take 2006-5 SCC 638. আমরা দেখেছি এই দেখুন
We have noted it, Mr. Pachawat.
Yes. Now, my lord, what these two judgments say, my lord, one of 2006 and the other of 2022, both by the Supreme Court, my lord, quoting full benches of my lord, various high courts around the country, approving of them. What they say is it is now mandated on the court to record findings and pronounce judgment on all issues. On all issues. And not there's a good reason for it. This is to avoid, not to use the language to avoid piecemeal trial, protracted litigation, possibility of remand on appeal, on an appeal court not agreeing with the trial court on the preliminary issue, and to ensure early finality of the list. So, that's not clearly stated. Now, given this, your lordship will see the mandate is now for deciding everything together. Take the evidence, decide them all together. Now, to get around it, My learned friend not showed a judgment, which I'll show your lordship, which says that, look, once it is held that the court has no jurisdiction, then it can't decide other issues. He cited a judgment. I'll show your lordship that judgment. What it says is, what it did was, but the court held that it has no jurisdiction and dismissed the suit. But despite having dismissed the suit, it granted reliefs. So all that the judgment says is, once you hold that there is no jurisdiction, you can't grant relief. That's all that it does, and I'll show your lordship the judgment. So, my lord, this does not answer the judgments that I have cited on Order 14, Rule 2. And the last point, my lord, I had urged was that territorial jurisdiction is a mixed question of fact and law, and we had showed your lordship not a judgment on that. Isha, reference take to Bolbe. But Isha Distributors, which is in 2019, 12 SCC 205. Yes. So, my lord, now given this, not even this question of now reading the plaint and getting rid of it may not be permissible. Your lordship will remember, my lord, Justice Rankin's, my lord, observation over there. It also says, my lord, it's important, I tell your lordship why. It also, my lord, quotes Justice Rumapal from Deutsche Bank, my lord, para 14 and 15 of the judgment, to say that, my lord, even difficult questions should not be decided on a demurrer. So I don't want to cite any new judgments.
এটার আরেকটা কপি আছে কি? আমার তো কপি হলে দাগ দেওয়া থাকে ভাই। এখানে কোনো দাগ নেই। এ আমার কপি নয় মনে হচ্ছে। অন্তত প্যারাগ্রাফ নাম্বার লেখা থাকে আমার প্রথম পাতায়। ওই তো দাগ দেওয়া ভাই। দেখে নাও, ওইটা আমার না, ওটাতেও নেই কিছু। 2019 12 SCC.
Lord, your lordship may just remember, I don't know, Lord, because very early days in our profession, but Lord, Order 7, Rule 11 applications used to be filed, and there were 3 or 4 very popular judgments not shown. One was, Lord, AIR 82 Calcutta, Lord, Ritu Sajdev's case, your lordship will remember. There was another, Lord, old judgment, 44 CWN or 1947 Calcutta. But these said very clearly, questions of difficulty should not be decided on a demurrer. And that was usually the ground to, Lord, dismiss a demurrer. Your lordship knows how it was in those days, Lord. 5 minutes, 10 minutes on a matter. No, this is a complex issue. Decide finally. So, Lord, this is how it was. Lord, Ritu Sajdev's case, Lord, was around that time. And then, of course, there's the other strange one, Justice Podda Khastagi is not one of those Order 7, Rule 11 applications. And I think Mr. Ghosh was being led by Mr. Kapoor. Lord, Order 7, Rule 11 application. So it discusses, Lord, the petitioners so-and-so. Mr. Kapoor appears for the petitioner. He has stated this. Mr. So-and-so appears for so-and-so. Then the reasoning, Mr. Kapoor has appeared for the petitioner. In those circumstances, the application is dismissed. We used to have a lot of fun teasing. So, my lord, these were the arguments which I had broadly made. Now, my lord, given this, now, my lord, let's just look at this. Lord, where does this lead us to? Number one, there was no question of deciding jurisdiction within the scope of the application. It could not have been decided even if my learned friend wanted it, besides this being an abuse of process. But the fact of the matter, it has not decided it either. So what is my learned friend's grievance, on the basis of which he can maintain an appeal? Besides not being able to show what's wrong with the order. Now, this not issue of suit for land, normally. Let's not also test this issue over here. Because I had not dealt with it saying, look, it's not necessary, it's not within the scope of the application. But my learned friend has again showed multiple judgments on it. Maybe your lordships think that there is no jurisdiction. So let me also satisfy your lordship on that. Not your lordship would once look at the praise in the plaint. My learned friend has not, of course, gone into the plaint, the merits, limitation, questions of ownership, title, all of that. But not if your lordship would once have just a look at the praise in the plaint. Lord, your lordship will remember to get rid of this even on a point of demerit, he also showed an affidavit of evidence. That, look, this is the principal question now. Lord, he has said it can only be done on the basis of the statements in the plaint. Then why rely on the evidence? Now, Lord, please see the praise. Let me, Lord, also. Lord, what are the facts over here? According to us, the plaintiff, there was a trust over this property. In breach of that trust, property was transferred. Now, how has this happened? A suit was filed in this High Court, and according to us, a collusive decree obtained in this court. On the basis of that collusive decree, and that is his submission also, on the basis of this collusive decree, my learned friend's client gets the property and obtains possession. That's the submission made. Now, but whether the land is in Alipur outside jurisdiction or within High Court jurisdiction, fact of the matter is I cannot touch him till I get rid of this decree. Because everyone's case is that the basis of his title is this decree. So I have to get rid of the decree. Now, there is a judgment, there is an act called the Decrees and Orders Validating Act, which I had placed.
Mr. Bachawat, I'm glad you raised this topic. That is a point has been troubling me. They say that that act does not apply.
I'll come to that. I'll come to that. I'm coming there, but I'm getting to the point. So, not the simple question of applicability, forget that. Let's drop that for a second. I'll go in there again. But point is, Milord, there is a decree of this court. Now, Milord, please see.
Can one say that a decree of this court cannot be assailed before any other court?
Right. Now that's the point. Now, Milord, please turn first to the plaintiff, or may I read it for your lordship? Now, Milord, we have assailed this decree in this suit. Unless I succeed, I cannot, Milord, have the title set aside. I cannot obtain possession. So my suit will fail if I fail on that prayer. If I succeed on the prayer, then a question may arise what happens next. But that makes it very clear that those other reliefs are ancillary. I have to first get rid of this decree. Now, my learned friend, I cannot proceed with this suit and get any other relief till I get rid of the decree. So, all the other prayers, let us assume they touch right, title, interest, everything. Let us say so. But they become ancillary.
Yes.
This is the first part. Now, coming to the second part. Before I go to applicability of the Decrees and Orders Validating Act. Now, I have not heard my learned friend, or rather, has he showed any judgment saying that it can be assailed in any other court? Now, Milord, I know. Now, Milord, we had only filed this suit in the Alipur court. Objection is taken with regard to jurisdiction there. So then I myself apply Order 7, Rule 10, and Milord, the suit is filed over here. Now, Milord, I have to have some forum to go.
Objection is taken with regard to jurisdiction.
Yes, by them. In Alipur.
On what basis? I mean, that act.
No.
Then?
Milord, they objected at the beginning. So we filed our Order 7, Rule 10 and came here.
What territorial jurisdiction? What kind of jurisdiction?
Yes. Territorial. I'll show it. So, Milord, the point is not there must be some forum. I can't be knocked about from here to there and there to here. Now, so Milord, suit filed in Alipur, I come here because it's challenging a decree of this court. Now, My learned friend has not cited any judgment to say that, look, I can't challenge the decree of this court in this court, and I must go back to Alipur court. Nothing has been cited by them. And mind you, we are now looking at only a decision in an application for commission.
On the other way, and I want to know
Yes.
whether decree passed by this court can be challenged before Alipur.
Yes. Yes.
Manoj, we have actually before the first court also cited two judgments which are there in our
They have,
notes of
Lord, he has
submission.
not cited them now. Lord, I'm not
Manoj,
making an argument.
it is
which I
there.
can't
We
find.
have cited that a decree can be challenged, passed by any court before another court on the ground of fraud.
I'm not disputing it. Maybe. But they've not cited any judgment to say that, look, I could have firstly, not fraud, no fraud. These are questions of fact which need to be gone into at the proper stage. Now, the point is I've applied for not cancellation or setting aside of the decree. Now, the Decree and Orders Validating Act says that the challenge must be before the court. I'll show your lordship the act. I had placed it. My learned friend has not made that argument at all. Please not bear it in mind. I had argued that because of the Decrees and Orders Validating Act, I can only come to this court. Now, in reply, my learned friend has completely avoided the issue. And that's why now, your lordship sees them.
We have already addressed that
jumping up
issue.
and down. Mr. Roy Chaudhary, I think, we didn't interrupt you when you were submitting. Now, my lord, the point here is the act says that it has to be filed before the court. Their defense was, look, that act has been repealed. That was their defense before the trial court. Your lordship will find it recorded in the order. To which we simply pointed out, look, there is a repealing provision which says that for suits which are pending, it will continue to apply. There is a savings clause. But please take
36 Act, Decree and Order Validating Act নাকি নাম দিয়েছিল মনে হচ্ছে না।
Yes.
Compilation. Attempt.
Yes. Now, my lord, their affidavit, so
Petition.
There's
There
a-
are Order 7 Rule 11.
So, my lord, their Order 7, Rule 11 before the Alipur court, but that's there in our compilation. If your lordship sees that.
The attempts, list of this with attempts written on. Yeah.
একবার দেখি এটা না ও আছে yes, this is the one. Yeah. Now this is their Order 7, Rule 11 before the Alipur.
It starts at page 12, at page.
Not
Where are you? In Delhi?
Not which
Yes,
is
Your Lordship.
no, he's ditched me in quite a few matters today. Now, my lord, this was their Order 7, Rule 11 in the Alipur court. Now, my lord, please turn to page 8. And have a look at, my lord, subpara 4, which is the second para from the top. This learned court has no jurisdiction to decide the validity of the sale of the property which was taken place pursuant to the decree of the High Court. They took the point. On that basis, I applied for transfer and I came here. Now, my lord, this is why I say this is abuse of process. But this has to be put an end to somewhere down the line. Did my learned friend not tell your lordship this at any point of time and then to argue this point? So, my lord, Decrees and Orders Validating Act says, look, you have to go before that court. My learned friend's defense was, well, that act has been repealed.
No, apart from that, I want to.
Yes, there are two things. Yeah, I'm coming to both the points on Doha. So his argument is that, look, the act is repealed. And I showed your lordship the savings clause. No reply given to that. My learned friends have not dealt with it in their reply and instead cited 10 more cases on blood suit for land, completely bypassing it. Now, Lord, this act is not annexed at page 187. No, it a repealing term. No, it I don't know, repealing term, yes. But 187 is the act and 188 is the repealing act. And not the learned judge had a look at it, and he said that the repealing act not takes care of not pending proceedings.
No, I'm
My
not.
learned friends have not tried to follow that. I'm coming to the second part. Now. My learned friend then says that, look, if you challenge it on the ground of fraud, you can go anywhere. That's his point. Now, Milord, he's not cited any judgments at this stage, nothing. I was not called upon to deal with it because he is not dealt with my act point at all. Otherwise,
If this act doesn't apply at all, that is what they are saying.
why will it not apply? Let's not read it once. No, why does it not apply?
Then repeal, not repeal is irrelevant.
Yes.
They are saying this doesn't
Agreed,
apply.
agreed. If it doesn't apply, question of repeal, no repeal. But he took the point squarely. On the basis of that, I've come here. But your lordship has seen the language of that para, sub-para 4.
Section 2.
Yes, I'm coming there. But please see again the language of his order, 7 Rule 11. But that's in accordance with the Act. This learned court has no jurisdiction to decide the validity of the sale of the property which has taken place pursuant to the decree of the High Court. He's specifically taking the point of this Act. Now, let's read Section 2, Sorry.
Respect to High Court decree has been claimed.
I'll just read the. I'll read the.
Just last part.
I'll read the para before the para which I had also read out. As my learned friend. The plain discloses no cause of action for the allegation that the said decree of the High Court is collusive, and accordingly no relief in respect of the High Court decree has been claimed in the suit, and this learned court has no jurisdiction to decide the question of validity of the decree of the Honorable High Court. So he squarely says that because of this act, you can only go to the High Court.
If they argue a wrong point of law, this is what we are. Look at Section 2.
I'm coming there also. I am not running. I am saying they took this point. Now, Milord, it's slightly clearer copy. I can't read anything here. But certain decrees and orders not to be called in question. No decree passed or order made by the High Court of Judicature in Bengal, High Court of Judicature at Madras or Bombay in exercise of ordinary original civil jurisdiction under Clause 12 of the latest patent, or by the High Court of Judicature at Rangoon in exercise of original jurisdiction under Clause 10 of the latest patent, shall be called in question in any proceeding before any other court, on the ground that the High Court passing the decree or making the order had no jurisdiction to pass or make the decree or order. So, Milord, you cannot challenge it in any other court if you take the point that the court had no jurisdiction to pass it. So that challenge has to be in the High Court itself. That's what Section 2 says. So, Milord, under this,
which in other words means, as I understand presently, that if the challenge is on a ground other than lack of jurisdiction, it is maintainable in a lower court.
Maybe. It doesn't say so. Then not one has to arrive at it inferentially. It says that a decree cannot be challenged in any other court. If you challenge it on the ground of lack of jurisdiction, then you must go to the High Court. Inferentially, not maybe possible to say in all other cases, you can go filing cases across the country. I am not on that. But let's read the section for what it says. My learned friend has been inferentially trying to say something, but his judgments don't say that, nor has anything he has placed say that. He simply says, look, if you allege fraud, then you can go to any other court.
So Section 2 was not a bar to your filing the suit in Alipur. It was not?
No, it was. It may have been. Because he says that act was in force at that time. And he says that because of this court, because of that act or otherwise, you can only challenge the decree in the High Court. That's his case. So I accept the invitation. I accept that invitation and I file order 7, rule 10 saying put it here. So then he realizes he is in from the frying pan into the fire because, my lord, let's put it this way. Alipur court would have been loath to touch a decree passed by the High Court. To get rid of my suit, he invited it. I accept the invitation and come here. Now, my lord, we can get into 20 kinds of complex legal arguments. Waiver, acquiescence, he has agreed, estoppel, he can't go back, and all of that. But no one can say this court does not have the jurisdiction. But we are not on whether it could have been challenged elsewhere. The question now is whether this court has the right to set aside a decree passed by it. This is the question. My learned friend has put it in such a way that, look, this court doesn't have jurisdiction because of this, that, or the other. Where does one get that? How does one get this, that this court does not have the jurisdiction? All that this act did was ousted the jurisdiction of other courts when it came to challenging a decree of the High Court.
On the ground of lack of jurisdiction.
Yes, on the ground of lack of jurisdiction. It ousted it. But does it not oust the High Court jurisdiction to try a suit filed which is challenging its decree? It's certainly not doing that. So, my lord, how this argument of my learned friend comes, I don't know. My lord, it's a case of, my lord, one can have a square, my lord, sweet called a Shandesh. Or one can, my lord, ask for a jilipi which goes round and round and round and round and ultimately leads nowhere. Now, my lord, these are nice academic issues, but what does it have to do with the case in hand? One can cite 20, my lord, principles. But what, my lord, where is the principle that this High Court will not have jurisdiction to challenge a decree passed by it? But it's nowhere come from any of his arguments. He simply says that because of this is no bar to filing of a suit in any other
They are
court.
saying if the setting aside of the decree affects title of property situation outside jurisdiction, then it's a suit for land.
That's a different thing.
That is the argument.
But that's suit for land. No, that's suit for land. Suit for land can't be decided on a demurrer. That is decided. That is decided. So, my lord, what does he do? He indirectly now tries to reopen it again. Like I said, that argument is closed. He now tries to bring it in by saying, look, this act which was then there is now repealed. That was the argument made. Not showing what the saving section says. Lord, you can't not make one argument there and another argument here. If my learned friend says this argument was not made, the order records his argument. So, my lord, if your lordship is with us on this, that one, this issue couldn't have been gone into at all. But I'm still prima facie showing your lordship that at this stage, look, my principal relief is that of getting rid of the decree. And unless I get rid of the decree, I can't get any other relief. Then, my lord, the primary relief being this. That's the end of the matter. My lord, this issue about it being a suit for land, not a suit for land. But we can go analyze these judgments, my lord, right from 1949, Lord, Calcutta, up to now. But the fact is, whether it's a suit for land or not cannot be decided on a reading of the plaint. That is a clear decision of this court up to the Supreme Court, binding. He can't touch it with a barge pole now. The attempt to reopen the issue again and again, Lord, like I said, is an abuse of process. But despite that, Lord, I'm still trying to show your lordship.
Justice Rumapal's division bench was carried to Supreme Court.
Yes. No. Oh, sorry. Lord,
No,
sorry.
your lordship, it wasn't.
Amendment. My fault. So, Lord, that point is over. Now, if I am right, Lord, in my contention, Lord, I can't get any other relief till not this decree is set aside. It is no one's case that this court can't have jurisdiction to try that relief. Because that portion can't be a suit for land. It's a decree passed by this court. And to say, Lord, let's also test his point. Lord, if whether the point of jurisdiction of the court is also involved, whether I am challenging the decree on the point that lack of jurisdiction. Lord, what is source? The plaint does take the point of lack of jurisdiction, but let's let's not what's sauce for the goose is sauce for the gander. But if I file a suit relating to Alipur court, a Alipur property in this court, there is no jurisdiction, that's their case. He also filed in this court and he got a compromise decree relating to property in Alipur. But will it ex specie be without jurisdiction or not? But he can't have it both ways. His suit will be with jurisdiction. It relates to Alipur property. And he gets a compromise decree by which a property in Alipur court is transferred for a paltry sum of 7 lakhs, 4 lakhs. And when I file the suit, this court has no jurisdiction. But please see the justice of the case. Your Lordship has to see, my lord, how much, how far or how long, my lord, someone can be fooled. But very well, we are lawyers, we are earning now for the last 25 years in trying to even move the suit 2 steps ahead. It's a struggle for the litigant. But there has to be some common sense at the end of it. The litigant has to see light at the end of the tunnel. But he goes to Alipur court, he's told no jurisdiction, come here. He comes here. But he has himself filed a suit over here, got a decree, a compromise decree, but under which a property in Alipur is transferred. And his is not a suit for land. Mine becomes a suit for land. But that doesn't make any sense to me. But these arguments, not contradictory arguments here and there. And my lord, whether I have said whether it's with or without jurisdiction, at page 458, I'll read one sentence from the plaint.
Yes.
Deliberate intention to commit fraud on the court for the purpose of invoking its jurisdiction and as such exercise of power by the High Court in passing the decrees wholly without jurisdiction. That's what the plaint
Part
says.
of your plaint.
Yes. So, my lord, to say it's not there, but my learned friend first creates a picture and then paints the law around it to say that, look, this is the situation, but base it on a factual foundation. He says you must go by the pleadings in the plaint. My plaint says so. Now, it may be correct, it may be incorrect, that's a different thing. But you go strictly by the pleadings in the plaint, then why argue these points? Not simple thing is not if the decree goes today, if this court sets aside the decree, his rights evaporate. That's his case also. Decree goes, his rights evaporate. Then how I get possession, don't get possession, we'll see. But I have to get rid of the decree and he can't get rid of my suit for that purpose. As long as my suit remains for the purpose of getting rid of the decree. But it can't be that a part of the suit will go and part will remain. It may be that the court may ultimately deny me the relief of possession, saying that for possession, file a suit. But your lordship is aware, but at the time when we had joined, but a bank would file a suit against a customer. For the money part, he would file in the High Court. For the mortgage property, he would file a mortgage suit elsewhere. So if the court says, look, ultimately, I'll set aside the decree, for possession, go elsewhere. Or for execution, go elsewhere. It's possible. But those are things to be decided once the suit is heard on merits. These are not issues to be decided on an application for appointment of a commissioner. Can't be done. But this is taking things to extreme length.
You have more or less completed, Mr. Bachcha.
Now, my lord, his judgments.
No, why I ask, we have to rise in 2 minutes.
Oh, I see.
There's a bench at the different bench at 3.
Could I do this, my lord?
Aski to bench ta.
But could I do this? On the judgments, I'll take possibly half an hour. No, suit for land, I've got rid of it in principle. Lord, let me in that case not see if I can just review the way in which I can not shorten the time.
When should we keep it? Tell us.
Not whenever it suits your lordship. Not
Monday.
Monday, কোথায় একটা fix করলাম.
Monday,
I have something.
Not this week. You choose your date, but not this week.
ওখানে কবে রাখলাম? সোমবার তো
Mr.
Lord, Tuesday first half এখানে
Bachawat, learned.
but possible to have it on Tuesday first half.
But, my lord, can it be on Wednesday?
Wednesday will be second half. Mr. Bachawat, learned senior advocate appearing for respondent oblique plaintiff, begins his argument in rejoinder but does not conclude. Paragraph as requested, list the matter once again on February 28, 2024, for further hearing.
Is the Monday court is going to function?
Can you query?
Monday
Can you query?
survey for
Huh?
the Muslim festival.
Oh, Monday, my lord, will there be court? Is what my lord.
Why this question at all?
Lord, he believes in many festivities.
Survey Bharat.
Oh,
ये तो हम जानता हूँ ना मैं तो मंडे फिर नॉट मार्क चले आप कितने ग्रेजुएट
October 28th.
Appellate side, item number 1 for judgment.
sorry, couldn't do it any faster because of
Indian, exactly. Here Bangladesh. Here Bangladesh বলে নাকি? তুই বল।
Mr. Devnath,
Yes, my lord. I am available for the Kolkata Municipal Corporation. This matter.
are you sure? You want us to dismiss the appeal or allow the appeal?
As you lordship speak,
What do
we
you
have
want?
made an, we want to dismiss the appeal.
You want us to dismiss the appeal? Sorry, we could not. We have allowed the appeal.
Yes, lordship.
The letter of intimation has been set aside.
Yes.
We are not satisfied that you can take the advantage of section 184 regarding the hearing notice. You have produced nothing to show even it was handed over to the postman. So fresh hearing will have to be given.
In consequence, Your Honor, all bills which have been presented will not stand because all bills are to be cancelled. If the fresh valuation is to be done.
Yes, hence the order of the hearing officer passed on August 29, 2011, confirming the proposed enhancement is bad, null and void, non-est.
Actually, consequence, Your Honor, all the bills raised on the basis that should not be
Relevant orders stand set aside.
My lord.
If that be so,
Automatically,
how,
that should be.
automatically, how will the consequential bill stand? It is now.
Original side matter for hearing item number 1 and 2.
Again, in order to
properties.
Yes.
completely for my own benefit. If I could just refresh.
It's very polite advocacy.
Because it's been a while, I'm also looking through the
That
notes
is why
that your lordship is. I've also not looked at it. But just to refresh my own memory really here. The disputed period is between 2000 to 2013. I'll come to the admitted facts later. 2013, a land acquisition proceeding is initiated. That lapses. By an order passed by a single bench, it's held, it's lapsed.
and the corporation is liable to pay me occupational charges. So the liability to pay occupational charges is admitted. Who is to pay is admitted. The period is admitted. This order gets carried in appeal. Then there's a division bench order. I'll have to place that because there's a question of another applicability of another act has been brought into effect, has been argued. So I'll have to place that order. That order also holds that till the award, the Act 1 will apply. Thereafter, for compensation and all that, the 2013 Act will apply, which is really the law. They are directed to pay occupational charges. A contempt is taken out where they don't pay the occupational charges because they don't pay it. In course of the contempt, they come and give us 74 lakhs. That 74 lakhs we accept, contempt gets disposed of because we've accepted that and we were not happy with the money.
That was Chief Justice Chellu. No, that was not Chief.
That was Chief Justice Chellu. Because in that contempt, because they say it was held that I'm entitled to compensation charges, they have to pay me. They don't pay me, so I file a contempt. During that contempt, they come and give me a check of 74. That 74 I accept, contempt gets dropped, but 74 we are unhappy. So we challenge 74. That 74, because we accepted in the contempt, the learned single judge holds that I waived my right or an
Shomatta.
Justice Shomatta. This is really becoming my memory. And then we accept it, that dismissed, come before before a division bench of this honorable court. There it's held that the 74 lakhs is
yes,
is done perfunctorily. Everything is set aside. The land acquisition collector is directed to undertake this entire process to determine the occupational charges and pay it in accordance with law. The land acquisition collector revisits the entire issue. It was held that 163, no?
162.
162. 162 is payable. Thereafter, there is a formula that is it's sent to his higher authority for vetting. A formula is sent by particular memo. It becomes 181 or 182.
118, 118.
From 1.18 to 1.6.
1118 to
161.
correct.
And what?
1118 to 162. This order gets challenged before the learned single judge here by way of their writ petition. I file another writ petition challenging because after the corporation files their writ,
Revisit.
there's a revisit.
These two, this is combined order of Justice Sinha.
Combined order,
Honorable Justice Subra Ghosh.
Justice Ghosh.
Acha.
Order of Honorable Justice Subra Ghosh.
But weren't the writ petitions at one point of time appearing before Justice Sinha? No.
My lord?
No.
At one point of time, were these writ petitions appearing before Justice Sinha?
No, no, no.
No. Oh, these are group one, yes, of course.
Group 1 matter. Now the challenge before the learned single judge and also here is primarily on three counts. One is persona designata. The collector was directed to do it and therefore the collector ought to have done it. The collector could not have acted on the dictates of his superior authority. That's one. Secondly, there is no basis on which 118 was arrived at, and that conduit between 118 to 162 is on the dictates of a superior authority, and therefore this was persona designata that should also go. So 118 is challenged on the ground that there is no basis. 118 to 162 is challenged on the ground. This was at the behest of a superior and not the land acquisition collector.
118, Mr. Banerjee, Mr. Ghosh, maybe it is arguable there is some basis. 162, absolutely no basis, apart from persona non grata.
So that without any basis, I don't know why he submits that because everything is there. But whatever, so that is that one bit of it. The other last challenge that was thrown was with regard to the applicability of which act.
Yes.
Which act will apply. But all these three issues with regard to applicability, it's clear that parties had gone, submitted to the jurisdiction pursuant to an order of court. They had gone. The collector, one important aspect is that the collector is entitled to determine or undertake this exercise. Neither is it open for them to challenge, nor is it under challenge. So the authority is not under challenge. It's just the basis which the court is looking into now. because now the previous division bench order and all the division bench orders where the collector was directed to undertake this entire exercise has not been under challenge. It is not the corporation's case that the collector could not have challenged. So who is to decide or what he is to decide is not under challenge. How is what is under challenge here. So which act will apply, all that I don't see where the relevance really comes in. But first I'll address your lordship on the question of how. So there is a detailed order which we had also placed on the last occasion, where the first 74 lakhs that was first arrived at was taking into consideration one particular property that the corporation accepted. But it was so perfunctory that it was set aside. Now when the collector undertakes the entire process again, he looks at two other properties. All these three properties were actually under government occupation. Our case was that because put together whatever formulas applied is come to approximately 10 rupees at an average.
Lindsay Street.
Lindsay Street, 10 rupees at an average. Well, there are some other judgments that I was coming across where occupational charges has been found to be much higher. But this was come to 10 rupees from 2000. So somebody who was in occupation of 1,000 square feet flat would be paying 10,000 rupees rent to somebody in on Lindsay Street. Now, this is unimaginable. But we had gone and said this was about 40 rupees. We had a valuer's report also saying what was the rent that was ongoing rent that was going on there. That has not been accepted. We challenged that, saying that 10 to 40 should have been looked into, but this became so cumbersome, we gave this up. And thought whatever at least we are getting, we'll get it because it's 2024. I'm still clamoring for occupational charges from 2000, 2013, practically after 6 rounds of litigation. Because 1, 2, 3, then again 1, 2, 3, then SLP, now again 1. So actually 7 litigations have happened for occupation charge from 2000, 2013 at 10 rupees per square foot. Now, if I could just indicate, Manoj, this aspect of whether this was persona designata at all, but that will probably border on the law also. So if your lordship could just have a look at page 78. This is, my lord, APO 207. Our name is spelling type with that. The spelling of my name, unless they thought I was African, this could not have, nobody could have written this spelling. Can
Page 70?
78.
Do you find your name there?
No, my lord, I find my name unfortunately on the first page of the paper.
I did point that out to you.
Yes.
Yes.
This is the order of 29th of December 2020.
Yes.
Where 118 is arrived at. If your lordship just turns over, my lord.
Yes.
In compliance disregards it because that's like a preamble. Then your lordship will find advocate for Rameshwar Properties submitted a set of documents, valuation reports, 40 per square feet. Sorry, page 79. First paragraph, kindly disregard.
Yes.
Second paragraph, Rameshwar Properties submitted documents, 40 per square feet.
Yes.
There's nothing else that I need to show from here, my lord. 80, first line, if your lordship could kindly make a note of. It has, sir.
Did not provide it.
207.
Did
Nothing.
not provide it.
So corporation did not have anything to say what the rate is going to be. Now, what does he consider? Two important things are there. Considering in order to determine the occupation charges at premises number 42 Ripon Street, As per government policy and guidelines, the LA collector has to rely on two government orders bearing 590 of 3/8/1993 for the period from 20th January 2000 to 29th April 2013 and 29th April 2013 for the period from 30th April 2013 to 15 December 2013. And then he considers 32A Brabon Road, 31 8B Lindsay Street. This was there when the 74 lakhs was also considered, and 31 Chaurangi Road. These properties he considers. He gives a detailed figure. 81, your lordship will just make a note of the area in square feet, 7031, because this will have a bearing on the last letter that was served upon us by the LA collector, almost at the behest of the corporation, because it reads that after the corporation has filed, following the filing of the writ petition by the corporation. So then they start sailing on the same boat. This figure or this area has never been under dispute. Then there's a full calculation of how this is going to be arrived at. 82 is the calculation for occupation charges. Now this, I say, is with regard to 118. Now the direction of the division bench was the collector, LA collector is directed to undertake this exercise to determine the occupational charges. If your lordship desires, I'll show that line, but this is what the line more or less is. 83 is where he says persona designata and the breach that I've gone. Kindly have a look at this one. To the LRC and Principal Secretary, Government of West Bengal, resubmission of calculation of occupational charges. Second paragraph, your lordship will kindly have a look. By this office memo under reference, the calculated amount of 118 was sent to you, to your end, for your kind vetting and authentication by your office memo number so and so, dated 19 February 21. The first land acquisition collector has been advised to recalculate the occupational charges as per formula shown in the said memo. I submit the same in triplicate. So all that is there is the determination is still being done by the LA collector. The determination really is what is 118. The reasoning that is applied to arrive at the figure. All that is done pursuant to the memo at page 83 is a recalculation of the figure, which is also being done by the LA collector. Now, most importantly, Manoj, this memorandum, I had made the submission on the last occasion, and I thought it found favor with the bench. Well, this memorandum of 19 February 2021 that is referred to at page 83 is not under challenge. So the basic order, when it's not under challenge, consequential reliefs on that can't be granted. And it can't be any party's case before a court. That when an authority is directed to determine in accordance with law, he will have to do so in derogation of circulars that are issued by the department. Circulars that are issued by the department, if not followed as they are binding, is actually malice in law. On these two counts, I'll cite two decisions, my lord. First is when a basic order is not under challenge, consequential orders will not be touched or be set aside to grant a relief to a party. This particular memorandum not being under challenge, therefore this difference can't now be under challenge. Second, my lord, non-adherence.
Devotion not under challenge, 29 June.
No, 19 February 2021.
February.
খুঁজে পাবেন না স্যার 83 দেখুন হ্যাঁ ওটা অন্যটা ভাবছে 83
Yes.
And non-adherence to a circular that is binding on a department is malice in law, And any action that suffers from malice in law is liable to be set aside. So when a direction is passed by a court to an authority to do it in accordance with law, law would mean circulars and interdepartmental notifications that are binding on that authority. So the fresh calculation is also provided for in this entire exercise. Lord, one document I'll just show at 87, your lordship will kindly have a look at. This is the first land acquisition collector writing to the Commissioner, Kolkata Municipal Corporation. First 4 lines, your lordship will leave. In compliance of the order, an exercise of calculating the occupation charge was made and the total occupation was assessed at 1,1852. The assessed amount was sent for vetting and authentication to the LRC and Principal Secretary of the Government of West Bengal. After proper scrutiny, an amount of 162,43,175 was vetted and authenticated by the LR. And the same was communicated by a memo dated so-and-so of the Joint Secretary to the Government of West Bengal, and a copy of the said memo is attached herewith for your kind perusal and taking further necessary action. It may be mentioned here that a contempt petition and then view of the same. You know, this letter comes about because of a particular letter that comes from the LRC. Ota kothay? Jera bocho ke move for payment. Yes, at page 85. So this is the Joint Secretary to the Government of West Bengal asking the first land acquisition collector that this is what you've sent me. Corporation has paid 74, last line, my lord. He is therefore requested to move the corporation to pay the remaining 88,11,735 as occupational charges. Then he passes 87. Once he passes this order at 87 with all these memos attached with it, he becomes functus officio. Because his jurisdiction was with regard to this particular determination. If I have to frame it in a legal way, my lord, once an administrative authority, and we had relied on several judgments on this before the learned single judge, and the learned single judge has also returned that finding. I'll be taking that liberty of citing those decisions before your lordship. Because after all, I'm not arguing the writ petition here. Your lordship's testing the learned single judge's order. Once an administrative authority passes an order,
yes,
he has no inherent power in him to review or recall that order unless he's authorized to do so. So that memorandum or the notice which we had to assail in our writ petition was assailed on this ground, on jurisdiction. Because both have been disposed of by a composite order, I'm having to mix this up.
So this is on the issue of revisiting.
On the issue of revisiting, that we had to challenge in our writ petition where we've succeeded. That you've become functus officio and we'll rely on those judgments. So 3 essential, the rest page numbers we'll give if your lordship allow us to give us a note. We'll give the page numbers. Otherwise, on facts, I don't think I need to trouble your lordships any further. So 3 essential points are, and this I had repeatedly argued before the learned single judge and had indicated here too, that the corporation has not been, or the appellant has not been able to show that the concept of persona designata travels outside of the legislative field. By an order, judicial order, concept of persona designata is foreign. More importantly, as your lordships also rightly pointed out when I was arguing this on the last occasion, it's a person and not a post. So it could be that when that order was passed, I was the land acquisition collector. It's possible that after I go, Mr. Ghosh is the land acquisition collector. So the office that undertakes it. Your lordship will give me half an hour on any other day, I'll finish it. except Friday.
This week. No, Friday, this bench
Huh.
is not available. Friday, I am not available. হ্যাঁ কবে আছে 27 এই 7 কোথায় ওকে ডাকো
নোট আছে পুরোটা
27th Tuesday. No, Tuesday. Tuesday morning, think about it.
No, এটা তো এই করে হবে
যখনই
Oh, sorry, not morning. No, no. This is not the regular bench.
Would it be on Wednesday, 28?
Another bench. It will be around 3:30. That should be all right for you.
Let it be there, of course. Well, I'll be trying.
Let
I
him
take half
finish.
an hour to finish.
Half an hour.
Half an hour.
Will you respond on that very day? In reply?
I'll tell me to complete it, my lord, on that day.
Very well. Then 3:30, huh? Mr. Banerjee, learned advocate appearing for the respondent Rameshwar Properties, resumes his argument but does not conclude it now. Paragraph as requested, let this matter be listed again on February 27, 2024, for further hearing. It will probably be 3:30 or 3:45. That will be indicated later.
Grateful.